Right. Good morning, everybody. Welcome back. I've got a few housekeeping matters I want to pick up on, but I think we'll do that after we've finished the examination in chief. Any housekeeping that we need to pick up on for this witness?
I think so. So my learned friends very helpfully handed in a copy of a committee report in relation to the Old Grove site that was mentioned yesterday, the one that recently got permission. That's been handed to Mr. Johnson.
May as well, yeah, let's get that in the inquiry. Sure.
But other matters can wait, sir.
Yeah, okay. Let's leave it then and conclude the examination in chief.
Thank you. Thank you. Morning, Mr. Johnson. Yes, so that you've just been handed a copy of the Old Grove committee report, I think, which is the site we looked at, one of the sites we looked at yesterday on the alternatives, which now recently got permission, and you took it off the alternatives list on that basis.
Yes, thank you.
All right, thank you. Now, just a few remaining topics to cover with you. First one is the issue of SANG in its various guises at this inquiry. Now, in your proof, in your table of benefits, you afford the provision of open pace and SANG significant weight. Could you just assist the inspector, if you can, just with the policy position in relation to thresholds for SANG, so far as the local plan is concerned?
Yes, thank you. Well, the policy position is set out in LPP2, which is CD 6.2.
Do we need to go there, or we just give the inspector a reference?
We don't have to go there. It's just for reference purposes. It's paragraph 7.14 of that local plan, which sets out a series of criteria based on site size and the provision of SANG.
So, in essence, what's the threshold in terms of number of dwellings where SANG may be required, so far as policy is concerned?
Thank you. Yes. The highest threshold is 50 dwellings or more, where the plan refers to may require a SANG and associated appropriate assessment for any planning application. So it's 50 dwellings.
Thanks.
And above.
And I was asking Mr. Jackson questions yesterday about that by reference to Mr. Kite's statement that was appended to his evidence. And I was asking about whether he was aware how many of the allocations in the district, on the face of it, if one applied those thresholds, would have required strategic SANG. Are you aware of that?
I believe it's 2, which exceed that site size threshold.
And those would be which sites?
There was the Royal School.
Yes, which is one of the sites
we discussed.
You've spoken to already, and I think you talked a little bit about SANG on that yesterday. You know, Carla Holmes is one of your clients.
Yes.
Was that relying on SANG coming forward either from this appeal site or elsewhere in the future, or was it?
No, I believe they have their own SANG solution. It's a combination of off and on site.
Right. And in relation to the other one was what?
I believe it's the Secrets, and I think it's referred to as Hurst Farm. In Milford.
And I think it's not in dispute that now has planning permission. I think Mr. Neems and others have told us that. How was SANG dealt with in relation to that site, if you're aware?
I understand it was, I think the site was close to the border of Guildford, and I think there was a separate application. So SANG was actually provided in Guildford Borough through a separate planning application, and I think it's probably secured through a Section 106 agreement.
All right, thank you. Good, all right, thank you. Anything else you want to say about SANG? You've given it significant weight.
No, just really a very quick reference, if I may, to the previous inquiry, the previous inspector's decision, where it was common ground between the parties that SANG be provided, and as a result, there would be no adverse effect on the integrity of the Wilton Heath SPA.
Yeah. Okay. Thank you. Our favourite issue of scout huts or scout facilities. Now, we heard from Mr. Butler at the outset of the inquiry about his concerns about getting a new lease, and he gave some evidence to the inspector about what had gone in from his point of view. Have you had an opportunity to take some instructions from the council about the position relating to the lease?
Yes, just discussions with property services. There is a draft lease. A bit of confusion around this whole issue. There is a draft lease that's been exchanged with the Scouts. The lease is based on, as I understand it, similar terms as the previous, which includes a peppercorn rent, and that has been doing a little bit to and fro between the authority, local authority, and the Scouts. But I don't believe there's a position agreed. I think it's just in discussion still. That's all I know at this stage.
I mean, so far as you're aware, what's the council's position and whether they are willing to give the Scouts a new lease or not?
Oh, the council are very happy to, in principle, to renew the lease on their existing premises.
Yeah. Okay. If that, let's assume that is the position, for the sake of my next question, and say the Scouts, if they wish to, can have a new lease. Just going back to the 190A considerations for the inspector about necessity or the need for a particular kind of development. So far as the part of this development is the Scout facility, how would you invite the inspector to weigh that aspect within the sort of general requirement of or consideration of need in terms of exceptional circumstances?
Well, I think from my understanding and what I've discussed with property services is that they have an existing premises. There is a discussion between them and the authority about renewing that lease. So they can stay exactly where they are. So in terms of, is there a need? Are they being evicted? No, they're not. Is there a need for them to find alternative premises? On the surface of it, as far as I understand, no, there's not. There's an existing premises and there's a lease being discussed.
Thank you.
Just before
Please,
we leave that, making that assumption, as you explained it, lease being talked about, not being evicted, they can stay where they are. Part of the proposal is a new Scout facility. What weight, if any, do you give that on the assumption that we're making about the existing facility? So what weight do you give the Scout facility that's now being proposed?
On the basis of what I just mentioned, I'd suggest limited, sir. Thank you.
So just final area was just planning balance really, and now you've got a table. If we turn in your proof to page 36, there's a heading planning balance above paragraph 11.4 of your evidence, and you've set out some points there, which we've seen. You've set out 11.4, a list of what you describe as material considerations that weigh against the appeal, and a number of bullet points, most of which I think we've traversed in your evidence in chief. And then you've identified at 11.5 fundamental and serious harm to the national landscape, which you give substantial weight. And then you turn to table 3, where you provide a summary of the adverse impacts and benefits associated with appeal proposals and give it various weight. And then you do a planning balance after that. What I'm interested in evidence in chief for you to assist inspectors, how you see the key differences between you and Mr. Collins, having looked at his evidence, the key sort of matters you think distinguish your inputs and perhaps the weight you give to various matters or consideration you give.
Yes, I can. Would it be helpful to run through the table?
Yes. Yes.
So, in terms of adverse impacts, the first one of those, this is paragraph 11.7.
Yep.
So the first one being harm to the character of the national landscape, which I afford substantial weight. I've got to substantial through my own assessment and through my review of the evidence, and also effectively an interpretation, if I may, of paragraph 189 of the framework, where 189 refers to, as I'm sure we're all well aware of this, great weight is to be given to conserving and enhancing landscape and scenic beauty of the protected landscapes. So with great weight, I've moved to substantial. In terms of getting to that decision, I took a bit of a reference to paragraph 212 in the way the framework handles heritage assets, and it will refer to in 212 refers to great weight for this conservation of heritage assets, and as we all know, substantial is referenced in heritage assets, whether it's substantial harm and non-substantial harm. So the framework associates great, if you like the wording of great, with substantial, and that's informed my decision. That hasn't driven it, but that's certainly informed it. So I'm at substantial. Mr. Collins is at moderate, if I understand. Yes, sure. So I'm at substantial, sir, as I mentioned, and Mr. Collins is at moderate. Moving down the table, loss of mature and semi-mature trees subject to a tree preservation order. Well, I've afforded that significant weight, sir. I believe Mr. Collins has referred to that as limited to moderate. Significant weight, I think, is largely the conflict with the adopted policies, the development plan, and also the impact, the loss of those trees. And I'm talking particularly in relation to the access onto Midhurst Road, the impact that would have visually and in terms of landscape character. And they're my adverse impacts, my key adverse impacts. Planning benefits, so provision of market and affordable housing, that is a benefit. I've associated that with significant, sir, and Mr. Collins is at substantial benefit. Now, I don't go to substantial. I think significant is the right level of weight. Not decrying the fact there's a housing land supply shortfall, but I think in reaching that balance, I've taken into account the council's year-on-year improvement in housing delivery. I've taken into account the fact that we have a call for sites process, we have an emerging local plan. There are other means of bringing forwards market housing and affordable housing, and as I say, the council are, in terms of delivery, doing very, very well. So I get to significance on both market and affordable, sir. Replacement of the scout provision, we've mentioned, I'm at limited. And that's also for the outdoor education facility as well. And Mr. Collins is at, I think, significant for the scout hut and provision of outdoor education. Moving down the list, provision of open space and SANG. Well, I'm at significant here. I think Natural England were probably at neutral, one of their, but surprisingly, but I think significant. It is important, as is open space, and I think Mr. Collins is at significant for open space and substantial for SANG. So similar but slightly different. Moving down the list to an accessible location for new housing. I think Mr. Collins and myself are both at limited for that. Provision of jobs supporting economic growth. Well, I'm at limited. Mr. Collins is at moderate. I'm at limited. It's a fairly indirect benefit. I think we discussed this yesterday. And I think it's a consequence of many developments. Some of those benefits are short-term with construction, and I don't think the effect of the scheme is going to make a particular impact, if you like, in terms of the economic and the prosperity of Haslemere. So I'm at limited there. 3 more to go. Incorporation of energy efficiency and electric charging points. I'm at moderate. I think Mr. Collins is at modest, so fairly similar. But it's energy efficiency, electric charging points. It's a fairly standard benefit and driven largely by building regulations these days. So I'm at moderate with that one, sir. 2 more to go. Inclusion of SUDs. I'm at limited. Again, it's a standard requirement of most developments, and just in terms of securing a planning consent. And I think Mr. Collins is at modest. And finally, providing a minimum of 10% biodiversity net gain. I'm at moderate. It's a fairly standard requirement these days, 10% of most developments above the threshold. And I think Mr. Collins is at moderate. That one, and I think that's it. Yeah.
Yes,
Thank you.
well, not quite it, because if you look in your proof, one thing you haven't covered, which is one thing you mentioned in your proof at 11.9, the previous inspector's decision, which you identified 11.9 of your proof to be an important material consideration. And you attribute significant weight to it, you say, in your evidence. So that's something, what do you understand, Mr. Collins? I think there's well, what do you understand he's done? Has he considered there's a material consideration, or what weight has he given to it?
It's waiting to the previous inspector's decision.
Yes.
I don't believe he has. I've attributed significant weight.
Yeah. Good. All right. Thank you. Overall conclusions then, you advised the inspector in your proof at section 11 on various matters and advised him to dismiss the appeal. Does that remain your position in light of the evidence you've heard so far?
Yes, it is. And three key points. Obviously, the appeal is in direct conflict with the policies set out and the reasons for refusal. Secondly, is in conflict with the framework policies on account of the fundamental and serious harm to the Surrey Hills natural landscape. And thirdly, the exceptional circumstances in paragraph 190 of the framework. It's not being demonstrated they exist. So despite the fact there's a shortfall, I had a land supply shortfall, my professional opinion is the tilted balance has not been engaged. It's by virtue of footnote 7. And in my opinion, the application should not be granted approval.
Good. Thank you very much for your answers. Thank you, sir.
Thanks very much indeed, both. Right, can we just pick up on some housekeeping matters before we go on to questions from Mr. Morici? I'm not going to run through my outstanding list of things that I'm due, just to note that it's becoming a moderately long list and we are moving in the direction of the end of the inquiry, but I know everybody knows what I'm expecting, and I can pick that up again probably tomorrow morning. Leave aside timetabling just for a second. Any other housekeeping matters that anybody needs to raise? No. Okay, timetabling. We've obviously heard the evidence in chief from Mr. Johnson. Mr. Morici, how long do you reckon?
So I think I'm certainly not going to be shorter than my time estimate, and I could run over it. So I think I'll be cross-examining until tomorrow. Yeah, I'll be cross-examining until tomorrow morning, I think, realistically. So I think in terms of where we are, we certainly will be able to call Mr. Collins in chief tomorrow. That doesn't seem to be any question about that at all. Whether we'll start cross-examination of Mr. Collins is probably a bit of a moot point at the moment. It depends how much progress we make. Maybe we don't, but we'll have to see how we go. Yeah. So that means probably realistically we're going to need to sit on Wednesday, which is one of the days we have, to finish the evidence, which I think we can probably comfortably do. Effectively what I'm hoping is it'll just be cross-examination from Mr. Cosgrove, Mr. Brown, re-examination. We should comfortably do that in the day, I think. And then we can deal with section 106 and conditions if we're all here. Seems like we might as well do that.
It'll be a very brief session.
Yeah. And then, sir, obviously it's up to you about when you want to do the site visit, but logically Thursday, because you'll already be here and other people will be here, would probably be sensible. And then, so that leaves the issue of closing, which I might just hand over to Mr. Cosgrove to explain where we are. Do you want me to do it or? Okay.
So I'd indicated, and Mr. Morici has been very helpful. In an ideal world, I'd like a bit of time, assuming I'm still cross-examining next week, finishing my cross-examination on Wednesday. I'd like a few days to do some closings, but I'm conscious of timing. I think we're both agreeing. I think the third party, we'd be happy to do that online if you were. I know you want to hear them. We'd come up looking at our respective diaries with the 6th of May, which is about a week later, which is a Tuesday. Now, you may immediately say, I can't do that. The three parties, Mr. Brown's very helpfully indicated that the Rule 6, we could all do that online to deliver closings, but that may be a non-starter.
It's sorry, Tuesday,
It's
6th
the
of
sixth,
May.
the 6th of May, so, yep, the week up, approximately a week and a bit after.
Sorry, just looking through my calendar. I've got a couple of meetings, one of which I would be delighted to move. Yeah, Tuesday, 6th of, gives me an excuse. Yeah, Tuesday, 6th of May works very well.
Well, I'm very grateful, and I'm very grateful to Mr. Marici for coming up with that day as well. So I know he's very busy, and for Mr. Brown, Mr. Brown is actually going to be on holiday, but he's indicated that another member of his team will be able to deliver the closing. So I'm grateful to him as well.
Okay, so we are looking then at just trying to make sense of my notes that I was making as we hopefully ran through it. So we're looking at the rest of today, cross-examination, which I'm sure will please you enormously. And then that will side into tomorrow. And then, yeah, we're looking indeed to be here on Wednesday, aren't we? I mean, by a significant amount. It's not a matter of shaving off the odd thing here and there. So we're looking at being here again Wednesday. Thursday site visit, we'll sort out the details, but yes, we'll do the site visit on the Thursday and then closings on 6th of May. Who is going to set up the closings on Teams? I'm conscious that I think the council don't seem to be using Teams, so I think we're running on.
Well, so, I mean, Savills can do it this side if that's easier, that's no problem.
We'll be able to work it out.
I'll leave it to the parties. I won't
yes.
get the inspectorate involved.
And the link is sent to case officer, is
Yes.
that right? Yeah.
Yeah,
Okay,
link to the case officer, and I'll obviously pick it up.
And then we'll have to put the link, when we send the link to the council, it'll have to go on the council's website.
Yes,
so that
we'll-
anyone who's
we'll-
interested can.
Absolutely must,
Absolutely,
yes.
make it clear. Yeah.
And I mean, as I say, I've obviously got no idea if there are any members of the public watching on the live stream. But when we conclude next Wednesday, I'll make sure that on the live stream it's made clear that there will be closing submissions on that date at a particular time. Okay.
So have you got a time in mind for the closing day to start? 9:30 or 10?
How long are you going to take?
Well, I'm.
Very roughly.
I don't. How long am I going to take? I don't know. Probably 3 hours or so, I reckon.
Yes, I'll be a little bit less. 2 couple hours.
9:30.
9:30. Thank you, sir.
Okay. That's absolutely fine.
Can I ask a quick question?
Yes. Of course.
When would you expect Rule 6 to be cross-examining Mr. Collins? Do you have an idea of what date?
Oh, it's probably going to be next Wednesday.
Next Wednesday.
Yeah.
I think that's
Yeah.
that's
No,
Wednesday.
that's
Yeah,
fine,
yeah, you'd indicated. Well, the timings I've got for Mr. Collins are 2 hours in chief, 3 hours cross-examination from the authority, and half an hour from yourself, and that's going to be Wednesday.
That's going to be, thank
Yeah.
you.
Okay, as I say, I don't feel inclined to go through my other list. They can wait, and there are matters that have all been mentioned before. And although I was starting to get a little bit twitchy about when those documents were going to come in, we're now going to be here next Wednesday, so I'm far less twitchy. Okay, so Mr. Marici, the floor is basically yours for the rest of the day, yourself and Mr. Collins. Where are we now? We're coming up to 10 o'clock. Can you look for a break at around 11:15?
Yes,
And
sir.
then obviously another one at about 1 o'clock, but I'll leave that to you.
Thank you, sir.
Okay.
Good morning, Mr. Johnson. Can we just begin by establishing the position in relation to your involvement in this matter? You were formally instructed by the council in February 2025, you tell us, correct?
That's correct.
And it proofs were exchanged on the 13th of March in this case. So it's right, is it then, that you were instructed only really a few weeks before proofs were due to be exchanged? Is that correct?
That's correct.
Now, in your proof, please, at 1.5. You say you visited the appeal site and its immediate surroundings, and I'm familiar with it, the appeal proposals and the background leading to this appeal. Now, as we established through your evidence in chief yesterday, you've never actually been on the site itself, correct?
No, I haven't. And just to expand slightly on that, I've obviously walked the public rights of way in the immediate area, but not physically walked on the site.
Right. So, I mean, the housing that's proposed, the majority of the housing, 110 of the units out of the 111, are proposed to go on 2 fields in LCA1, the northern part of LCA1 and LCA2. And we've agreed, haven't we, with Mr. Petro, that in very large part those fields are invisible from public viewpoints, correct?
I would disagree with that point, if I may just expand on that. The very first time I visited the site, I walked where the public rights of way, where it meets Midhurst Road. As you walk along that footpath, fairly immediately, there's a view up the hill to the left, and you can actually see the rear of existing properties. So that view is going to open up very quickly to users of that right of way once development is there. And obviously, as you walk along that footpath, you get a very clear sense that the reviews, the sites, there's intervisibility between the users of Midhurst Road, the users of that right of way, and the site.
Well, I mean, let's break this down. So Mr. Petro's evidence was clear that the fields on which we're building the housing are going to be very largely invisible from public viewpoints. Now, you can disagree with him if you want, that's absolutely fine. But I think I need to understand with you, if you're going to give that evidence, where it is exactly that you say you saw these fields from. So could we go to Mr. Smith's proof of evidence, please? Because I think that's probably a good place to start on this. And at page 19.
Oh, excuse me, may I just have the
Yes,
number,
so
please?
this will be NID 5.3.
NID 5.3, thank you. Thank you.
So NID 5.3. Now, when you get there, let me know. It's page 19. You should have the annotated illustrative master plan.
Page 19. Yes, thank you.
So can I just check with you? It might be easier if I hold this up and show. There's a corner point up here, isn't there? A corner of the site up here.
Yes.
Is that where you're talking about? You get a view through to some of the housing here and to the top part of that's the northern part of field LCA1.
Yes, there's a certain stretch along that footpath that you do get the views of the rear of those properties.
Well,
Yes,
certain stretch.
it's in that vicinity.
So it's around here at the top.
Yes, on that footpath.
Yeah,
yes.
but I mean, for a large part of when you walk along the footpath down Midhurst Road, you don't get to see anything of those fields through the trees, do you?
I think you would. You do see views through.
So
it's not a continuous screen of vegetation along that footpath. You can see the slope leading up towards the rear of those existing properties.
So can I just be clear, because I'll have to record this. I mean, your views about what can be seen of these fields completely at odds with Mr. Petro, who's given the landscape evidence. Is that right? Because he was very clear that the housing will be well nigh invisible from public viewpoint. So you disagree with your own witness in relation to visibility. Is that right?
I'm not entirely sure that Mr. Petro was talking specifically about the point we're talking about here.
Well,
but certainly, and the inspector will reach his own view on the site visit. But
well,
there's clearly a view of the existing properties. So the proposal will be in front of that view, if you like. It'll be very evident.
Can I just understand? I need to know from you where you're saying it's going to be visible, because this is new evidence. It's not the evidence of your witness. So I need to be very clear. You're saying there are going to be viewpoints of the housing, both at this sort of top corner point, but right the way down here. Is that right?
No, that's not what I'm saying.
So where is it going to be visible from? This corner point, I would agree with you. There probably would be a view, depending on, of course, what planting goes in here. But there would be a view of, if you went to there today, there'd be a view of the northern part of LCA1 field, at least some of it anyway, yes?
Yes, I don't think we're that far adrift.
No.
I think we're fairly agreed
So
that that
it's-
is the point where it's
That's
most
the
evident,
point. So
yes.
it's really at that corner point, isn't it? And maybe just past the corner, is that right?
Yes, thank you.
All right.
Yeah.
Now that's fine. Now, LCA2, which is where all the housing goes over here, that's not visible from there, is it?
No.
No. Now, just to understand that a little bit further then, please. I mean, also, we have, don't we, a proposal within the site for both the Scout facility and there's a clearing for the Woodland School. You haven't seen those locations at all, have you?
No, I haven't.
No. Now, just to understand your evidence about this, so if we look at your proof, please, at paragraph 9.33. You say, I've undertaken my assessment of the proposed visual aspects of the appeal scheme, having visited the site and the surroundings on the 6th of February 2025. And just pausing there, I mean, you've visited the surroundings to the site, but I mean, you haven't been on site as we've established. And you say, in my review of the appellant's landscape visual impact assessment and provide an assessment of predicted visual effects with the magnitude of significance effects of each view assessed during construction and completion. I've also had regard to the statements of case, and then you talk about Mr. Clive Smith's view. So when you say you've undertaken your own assessment of the proposed visual aspects of the appeal scheme, that's the assessment that we see, isn't it, in your proof that runs from paragraph 930 through to 947, correct? That's your own assessment of the visual and indeed the landscape impacts, correct?
Yes, that is correct.
Now, in relation to that assessment, your own assessment, in terms of the weight that one would give to that, we must take into account, mustn't we, that you have never actually been on the site, correct?
That is correct, but just to very briefly expand upon that, the key issue here is the impact on the receptors. So having walked the footpath, which is a highly sensitive receptor, that's how I've reached that view. And also, I've also taken into account the views from the rear of the properties on Scotland Close as well. But you can't actually see that from the public highway. They're the residents who will see that from the rear of those properties. But from a public point of view, public access point of view, my assessment has been undertaken purely from walking of that right of way.
Well, I'm just a minute. I mean, you say the important point is the receptors. You're talking about visual receptors, aren't you? Not landscape receptors. Because the visual receptors are viewpoints from outside the site. Agreed. Yes.
Yes.
Now, I'm not going to rehearse where we've got to on visual impacts with Mr. Petro, but I mean, it's fair to say that wasn't really the key part of his case. He was concerned more about the landscape impacts. Now, the landscape receptors are fields LCA1 and LCA2 themselves, aren't they?
Yes,
And you haven't been onto LCA2 at all, correct?
that's correct.
And insofar as you've seen LCA1 from peering through the trees at the corner of the site, you almost certainly haven't seen all of LCA1 either, have you?
No.
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 Okay. So that's a starting point in terms of your assessment. And when I read through your section C of your proof that runs from 9.30 through to 9.47, I mean, correct me if I'm wrong, but the entirety of the focus of your evidence in this section is based upon the impacts that will be caused by what we are proposing at the access. So the lodge, the access road, the retaining wall, etc., etc. I don't see in this section you referring to what the impacts would be from the actual 110 houses on LCA 1 and 2. If I'm wrong, can you just tell me where in these paragraphs we best see your assessment of what the impact would be on these two fields, one of which you haven't seen at all, but where do we see your assessment of that?
My focus has been on the effects of the access.
Yeah, effects of the access, well, which makes sense because that's what you've seen, whereas you haven't actually seen the fields, certainly one of them at all, where the housing goes.
Well, just to jump in very quickly, I don't think that's entirely correct because when you refer to what you see, what you will see, just going without wanting to go over old ground, is the view from the public right of way as you enter onto it from Midhurst Road. You will certainly see the development from that point.
Yeah, that's
So-
you'll see some of the development in field LCA1, but you wouldn't really sensibly be able to give this inquiry a view about the impact on LCA2 as a landscape receptor because you've never seen it.
Yes, no, that I've left that to the evidence of Mr. Petro.
Right, okay. Good. Now, can I just understand one other point with you, please? In your evidence in chief this morning, you went to your table 3, which is on page 36 of your proof, paragraph 11.7.
Yeah.
And you have an adverse impacts section, and you say harm to the character of the national landscape. Is that landscape harm or landscape and visual harm or just visual harm? What is the harm to the character that you identify to be substantial here?
It's landscape character, it's visual and it's landscape character.
So it's visual and landscape.
Yes.
Right. But I mean, you understand that in terms of visual, Mr. Petro's evidence was that even at year 10, we're looking at moderate and slight impacts visually, and by year 15, all slight. So his focus is more on the impact on the landscape. So is your focus more on landscape than visual here, or not?
I believe, I believe Mr. Petro's substantial adverse effects.
Yeah, but he corrected that because he got it wrong. Remember, he said it was substantial, but he got it wrong because his table actually showed it was moderate visually at year 10, which is the residual year. So when we amended his evidence, it was moderate at year 10.
So you're talking,
Landscape.
the answer is related to landscape.
Yeah,
compared to
landscape.
visual.
Okay, visual. Well, visual we got to
Landscape
slight.
didn't.
Visual we got to slight across the board at year 15. Yeah, and he actually did correct his answer on visual impact because his summary of visual was substantial at year 10, but he realised that that was wrong because his tables actually showed it was moderate or slight, but moderate was what he went for. Okay, so it's not, he never comes to substantial on visual, but he obviously gives an answer for landscape which is different, and he doesn't amend his answer on that, although he did change his terminology from substantial to large. So I just want to understand, when you talk about this, is this mostly like Mr. Petro about landscape, or is it for you landscape and visual?
I'm not disagreeing with Mr. Petro,
No,
it's landscape.
All right. Now, just one other thing. You said when you were explaining why you'd afforded it substantial weight, you said something this morning that I didn't quite follow, which was that you'd looked by way of an analogy, I think, to the position in relation to heritage harm. Can you just run that past me, because I'm afraid I lost track of what that was really saying.
Yes, of course. So we're all aware of paragraph 189, the
Great
framework that refers to grade. Now my weighting scale, not dissimilar to Mr. Collins, starts at substantial, significant, moderate, goes down the list like that. So I've given this the highest weighting. I have taken reference to the MPPF, and my interpretation of great weight is substantial. And the contextual point I made in relation to paragraph 212, as we all know, that relates to heritage assets. Now, the framework talks about great weight should be given to the conservation of heritage assets. A bit like great weight is given to conserving, enhancing landscape. So it talks about great in relation to landscape and heritage. But in heritage, as we all know, heritage is often dealt with in terms of substantial harm and non-substantial harm. So the two words, without moving too much into semantics, great and substantial are used almost in a similar conversation, if you like, for heritage as it is, in my view, in landscape, and that's how I've got to substantial.
Yeah, I thought that's what you said. Now the problem is you're confusing two things here, quite fundamentally confusing two things. There's a difference between harm on the one hand and the weight one gives to harm on the other, isn't there, Mr. Johnson?
Yes.
Yeah. So in heritage, we give great weight, don't we, to heritage harm, correct?
Yes.
And we give great weight to that harm, whether the harm is less than substantial or substantial. Yes?
Yes.
So you can't, can you, treat great weight and substantial harm as being analogies to each other, because one is dealing with harm and the other is dealing with weight. They are completely separate concepts, aren't they?
They are separate, although just to add a little bit to that, the key point here is that it's the weighting I've afforded to that, the harm to the character of the national landscape is at the top of my scale. And that's how I've got to substantial. I have taken reference to the NPPF and drawn that analogy, but for me, it's right at the top in terms of weighting.
What's feeding into, I mean, this is what I don't really follow, is when you're talking about harm to the character of the national landscape, are you feeding in here both the level of harm and the weight to be given to it? Because presumably, even if you concluded that the harm to the national landscape was the lowest amount of harm one could have to the national landscape, you'd still give that great weight, wouldn't you? Because any harm to the national landscape has to be given great weight. So what's feeding this substantial? You seem to be drawing into this both harm and weight. Is that right? And how does that work?
Just for clarity, I am talking about weight when I refer to substantial.
Right. So any analogy with the phrase substantial harm in heritage is completely irrelevant to this discussion, isn't it? Because that's about harm, not about weight. It's a bad analogy, isn't it? Just we give that one up, shall we? Move on.
It's the analogy I drew.
I know it is, but it's a bad one, isn't it? Because it's got nothing to do with weight. That's only to do with level of harm, and that's not what you're discussing.
Yes, okay.
All right, thank you.
Yeah.
Now, right, let's move on to a different topic, please. I want to just understand the scope of your evidence before we get going in detail. So paragraph 1.9 of your proof is a good starting point, I think, for this. Because in your proof of evidence at 1.9, you say, I consider the relevant planning policy context, provide my opinion on the contribution the development will make to the social, environmental and economic objectives of planning and other material considerations. So
Yes.
you're setting out to tell us what your opinion is on the contribution the development will make to the social, environmental and economic objectives of planning. Yes, those three key objectives, correct?
Yes.
Now, the case that the council advances at this inquiry through both your evidence and Mr. Petro's evidence is confined, isn't it, to alleging adverse impacts from the scheme only on the environmental objective of those three, correct?
Yes.
And on the social and economic objectives, the proposal is in every respect positive and provides benefits, correct?
I think I
Was that yes
wouldn't
or no
entirely
first?
agree with that. I
Well,
wouldn't entirely
yes or
agree
no
with
then? No?
that. No.
Okay.
And if I can just expand a
Yeah.
little bit, I've dealt with the economic effects, the benefits in my weighting.
Uh-huh.
I think from a social perspective, I think you've got to be a little bit careful with that because obviously, you know, this is going to impact the character of this scheme has an impact, isn't it, in terms of landscape terms, and there is a social connection there because you've got people, members of the general public using the right of way and how they perceive their environment and how they perceive the countryside is a matter of is a social issue, not just I would suggest an environmental issue.
Well, let's break it down. So on economic, one of the three objectives, we're agreed that in every respect, the scheme is positive, correct?
At various weightings, yes.
Yeah, I mean, weightings will come to, but
Yes.
it's positive. Now, on social, you're suggesting that the landscape harms that the council identifies could also be seen as social, is that right?
Yes, I do, yes.
Yeah, so I mean, I'm sure Mr. Collins will be taken up on this next week by Mr. Cosgrave in relation to double counting, but it's the same harm, isn't it, the landscape harm that you're carrying into both the environmental and the social. It's not a different harm, it's the same harm, isn't it?
The harm I referred to is environmental.
Yeah, the harm you referred to.
I suppose, just
Yeah.
to say, I am disagree. I don't think you can draw the conclusion that there will be, if you're developing in a nationally important place, such as a national landscape, the whole point of the designation is to safeguard that for the benefit of the current and future generations. And that's, as well as for its own purposes, but there is a relationship there. But for me, the key focus is on environmental impact.
Yeah, I understand that, and I'm going to come to that. So, I mean, the council's case essentially is focused on the environmental, yes?
Yes.
Now, can I just come back to one or two things on the social? So first of all, are you actually alleging social harm from this proposal? So is there harm to the social objective from this proposal? Yes or no? You might say to me, you don't agree there's a benefit or whatever, but are you alleging harm?
No.
No. Okay, good. Now, the second thing is there are social benefits from this scheme, aren't there? And we'll come to them in more detail. But for example, 78% of the site, over about 20 hectares, which is currently not publicly accessible, will become publicly accessible. That's a social benefit, isn't it?
Yes, but that will leave the 5 hectares that's
Yeah, but that's a
development.
social benefit, okay. And of similarly, provision of affordable housing, I mean, that's well recognised to be a social benefit, isn't it?
yes.
Yes, good. Now, so the council's case, thank you for confirming, is focused on there being harm to only one of these 3 objectives, which is the environmental objective. Now, on that environmental harm that you allege, could we look at 9.3 of your proof, please? You say at 9.3, first line, halfway through the line, I have not advanced any case relating to impacts on recreational opportunities or non-landscape related elements of the environment with regard to criteria C. So just to be clear on what you're saying there, it's no part of the council's case to allege any adverse impact on recreational opportunities, correct?
That is correct.
And in fact, there is recreational benefit because 78% of the land which is not accessible will become accessible, yes?
There is some benefit to that, yes.
Yeah, we'll come to the level of benefit later. And then you're also not alleging any other environmental harms that are not landscape related. That's what you say there, isn't it?
That is correct.
Yeah, okay. Thank you. And in fact, again, there is benefit, isn't there, in other non-landscape related environmental matters. We'll come to how much weight, but for example, through the provision of net gain, biodiversity net gain, yes?
Yes.
Yes, okay, good. Now, in addition, the sole focus of the council's case is on the environmental objective. In relation to 70, and obviously in relation to that, landscape as basically the only thing really, isn't it, that's causing the environmental harm?
Yes.
Yes. And in relation to 78% of the site, and in relation to what we've called LCAs 3 to 7, the position is agreed, isn't it, between Mr. Smith and Mr. Petro, that it's beneficial in landscape terms across those 4 landscape areas across 78% of the site.
Yes.
Yes. Thank you. And then if we look at if we go to your page 33 of your proof, actually, no, sorry, not page 33. Again, if we go to your page 30, this is the section we discussed a moment ago, the impact of the appeal scheme on the landscape and the extent to which it could be moderated. Do you remember when I asked you about this about 10 minutes ago, you accepted that the focus of the landscape harm that you have assessed and identified and explore through these paragraphs is in relation to the access, yes?
Yes, that's broadly correct, but there is obviously, we do have, going back to that point about the view from the public right of way,
Yeah, okay, well,
further towards the point where it joins Midhurst Road.
yeah, well, okay, I mean, we'll keep coming back to that, but you did accept very clearly when I asked you this, that the focus of your evidence in C was pretty much entirely, isn't it, on the access? I mean, do you mention, I'd asked you this earlier and you didn't come up with anything, so I ask you again, is there anywhere at all in this section, C, which runs from page 30 to 33, where you refer to landscape impacts from the 110 houses as opposed to the access?
At that point. No, but
No.
I won't go any further with that because obviously the inspector will undertake
Yeah.
site visit and draw his own conclusions
Okay.
from that.
So I'll take your no, that's fine, thank you. But just to be clear on that, so in terms of your assessment and the landscape harm, which is the only element of environmental objective that you allege to be harmed, your focus is on the southern part of LCA 1 where the access is.
That is my focus,
Yeah.
yes.
Okay. Good. Now, just to be clear on this, we've kind of had some exchanges on this already, but on landscape and visual impacts, whether they're positive or negative, you are, I assume, largely relying on Mr. Petro's evidence, and you defer to the answers that he gave to me, correct?
Not entirely correct, I'd
Right,
suggest.
okay.
I am relying on Mr. Petro, but there are other evidence documents in addition to the proof. There is the landscape visual impact assessment, and obviously we have the representations from Mr. Smith, the AONB board, to take into account as well, in addition to the Rule 6 party comments, of course, as well.
Right, okay. Well, let me just break that down into two things, first of all. I asked Mr. Petro a whole series of questions about what the level of landscape and visual harm would be. You're not going to seek to dissent from any of the answers that he gave to me about what those impacts were, are you?
No.
No. But secondly, if we go to your paragraph 9.33, and this is, I think, to pick up on the point you've just made to me, and I want to be fair to you about it, you say there that you've based your assessment on your site visit, which I'm not going to go back to, but we know what the limits of that were, but also your review of the appellant's LVIA, which is what you just mentioned to me, correct?
Yes, correct.
Yeah. And also the views of Mr. Smith, and I think also a bit further down the page, the chair of the Surrey Hills National Landscape Board, and I'll come to their views in due course.
Yeah.
But those are the things that you've taken into account in reaching the view that you have in your proof on the landscape impacts, albeit that you are focused on, as we've agreed twice now, the access impacts, correct?
Correct.
Yeah, okay. Now, of course, what you hadn't seen, correct me if I'm wrong, but obviously when you wrote this proof, you wouldn't have seen, would you, Mr. Smith's evidence, because they were exchanged at the same time?
That is correct.
Yeah, that is correct. Okay, good. Now, just finally on the scope of your evidence, please, can I ask you to go to section 4 of your proof? And in section 4, you set out the original 6 reasons for refusal across pages 6 and 7. And you explain in 4.3 that reason for refusal 2 has gone. That was the ecological reason for refusal. And then you explain, don't you, that in relation to 4.4, it's anticipated that reasons 3, 4, and 5 will be satisfactorily resolved if section 106 is agreed, correct?
Correct.
Yeah. And I think reason 6 has gone anyway, hasn't it? That's about the safety audit. That's long gone as a ground. So we need to not worry about that. But you say at 4.4, at the time of writing, a draft section 106 document had not been received with regard to this appeal. And then you say the council will provide a civil justification document in advance of the inquiry. I think we're getting to the inspector's list of outstanding matters here. But rather than just to understand this, I mean, you realise, of course, don't you, that there was a fully agreed section 106 for the purposes of the previous appeal, yes?
Yes, and legal advice we received that when the appeal was quashed, then the section 106 was also quashed.
Yeah, of course, but that 106 had been fully agreed. I mean, I think the reality is the 106 never kind of bites because there's no planning permission for it to attach to activate it. But
Yes.
but leave that aside. I mean, we had agreed with the council at last inquiry all of the matters in the 106, hadn't we? By the end of the inquiry.
Yes, although those matters have evolved since
Yes.
that point.
Right.
Yes.
So and in terms of how these points have evolved, I mean, the things that have changed, and I think you do explain this somewhere in your proof. I mean, obviously, there was a separate obligation last time round that we were offering allotments, and that's gone. We're not providing those anymore.
Yes.
And then the other things that have changed, we're also offering, aren't we, a financial contribution towards off-site affordable housing in addition to the affordable housing on site. That's new, isn't it?
That is new, and I understand there's a new clause there which involves a clawback/cascade mechanism to see that delivered.
All right.
Yes.
And then the other thing that's changed more recently, or at least we've proposed to change, just so I can understand the scope of this, is we've offered an obligation in relation to seeking to sort of commit to the larger SANG, which we'll come to in more detail. But that's another change that's come up recently, yes?
I believe from Mr Collins that change has been introduced, although I haven't received any feedback from the borough solicitor yet on that, but I believe that's posed in draft, yes.
Okay, thank you. So we can pick all this up at the 106 session, but beyond these things that have changed, I mean, there's not a huge amount of disagreement, is there, on Section 106?
No, there isn't, no.
Okay, good. Thank you. Right, now, I want to turn to, at the outset, an issue that will obviously lie between us, which is the previous appeal decision on this scheme. Now, there is obviously a dispute between the appellant and the council, a legal dispute between the council and the appellant about whether our inspector can lawfully have any regard to that previous decision, and if he can lawfully have regard to it, whether he should have any regard to it. Now, I'm not going to debate with you the law on this because that wouldn't be appropriate, but there are a number of factual matters that underlie this that I need to explore with you. So first of all, can we just explore the factual circumstances surrounding what happened to the previous decision and why it was quashed? And I think probably what we want to do is, could we look at NID 1, please? To start with, so NID 1.
Thank you.
Have you found that?
Yes, I have.
Yeah.
Thank you.
So this was a consent order and it was agreed, wasn't it? You can see from both the heading and actually from the signatures which appear at the bottom of page 2 that the order was agreed by the appellant, the Secretary of State and the council, correct?
Yes, that's correct.
Yeah. And if you go, please, in this document to electronic page 3 to paragraph 7, this is in the schedule to the order, and the schedule explains the reasons why a decision is quashed when it's quashed by consent. And 7 says the first defendant, that's the Secretary of State, accepts that Rule 18.3 of the rules required the inspector to notify in writing the persons entitled to appear at the inquiry who appeared at it of a matter in question and to afford them an opportunity of making written representations to him or to ask for the inquiry to be reopened. The claimant was not notified of the issues nor afforded any opportunity to make written representations, nor provided with the planning inspectorate's correspondence to the HSRA. So that's effectively a sort of very brief summary, isn't it, of why the decision was quashed. It was about procedural fairness, yes?
Yes, that's my understanding.
Yeah.
Yeah.
Now, if you then go down to the next page, paragraphs 10 and 11, it's recorded for the avoidance of doubt, this is paragraph 10, the claimant reserves its position on grounds 1, 3 and 4 of the claim, and the first defendant, that's the Secretary of State, does not concede on any other grounds of the claim. 11, however, the parties are agreed that the appeal decision should be quashed on ground 2, that's the fairness ground. The parties also agree that the other grounds are academic in the context of these proceedings, as it's agreed the decision is to be quashed on ground 2. So just to understand the position, I mean, the position is that because everybody agreed the decision must be quashed on the fairness ground, there was no purpose in arguing the other grounds because they would be academic, because the decision is going to be quashed anyway, yes?
Well, not quite how I read it. This is obviously getting into matters of law here, so I have to be a little bit careful with stepping outside of my bag, as it was. But as far as I can understand, the Secretary of State didn't concede to any of those other grounds, and neither did the inspector.
Well, that's not how it works. I mean, when an inspector's decision is challenged, it's the Secretary of State who decides whether the claim is conceded or not. So, just to be clear on this, I mean, it's absolutely clear, isn't it, that we maintained that those grounds were good grounds. The Secretary of State said they weren't accepting them. But they were never argued. There was never an opportunity to argue those other grounds because everybody agreed that it was going to be quashed anyway on ground 2. So everybody's positions were reserved, weren't they, on those grounds?
But I don't think you can use that argument to dilute or weaken the procedural unfairness.
Well,
ground.
I think you can, and that's what I'm going to explore with you. But all I want to understand is the factual position with you. This order records, doesn't it, factually, that everybody's reserved their position on those other grounds, us and the Secretary of State, correct? Yes, we both reserved our positions. No one's conceding whether grounds 1, 3 and 4 were right or wrong, correct?
That is correct. No one
Yeah.
is conceding.
And what's being said is that there's going to be no determination of those issues now because they're academic, because it's going to be quashed anyway, correct? That's what it says in paragraph 11, doesn't it? I just want to establish the facts, but that's what it says.
Yes,
doesn't it?
well, just to say that in terms of whether it's academic, it does use that word, yes.
Yeah, it does use that word. Okay, fine. Well, that's good. Now, just to understand that, I mean, the other 3 grounds, we've got them in NID 1.6. So could we just look at that, please? NID 1.6.
Thank you.
Now, if you go to electronic page 9 to start with,
Yes.
and again, all I wish to do really at this point is to establish the facts, and I'll come back to what the consequences of those facts are in a moment with you, but just to establish the facts. But the grounds on which everybody reserved their position and on which the court didn't rule because it wasn't necessary to, it was academic. The first ground is apparent bias, yes?
Yes.
Right. So it's an allegation that the previous inspector's decision was tainted by the appearance of bias, correct? That's the allegation.
That's the allegation.
Yeah. And then if we go down to page 11, ground 3 was that, I don't go into the detail, but just look at the heading, that the findings of the inspector on SANG benefits were based on a material misunderstanding of Natural England's advice, or they were irrational, or they weren't fully reasoned. And then ground 4, the final ground, if you go to electronic page 15, go to electronic page 15, was that there was an inadequacy of reasons by the inspector in relation to his conclusions on biodiversity net gain. So that's factually the position, isn't it? Those are the grounds on which positions were reserved, yes?
Yes.
Yeah. Now, I just want to understand those with you. There's a document, which I'll just show you. I don't know whether you've looked at it, and if you haven't, there's not really much point me asking you questions, but let me just ask you whether you have seen it. So this is in NID 7.46.
7.46.
Yeah, NID
NID.
7.46.
Bear with me. Yes, thank you. I have that.
Have you ever looked at this before? It's a series of internal emails within PINs. Have you ever looked at it?
I have read it.
Right.
Yeah.
Now, do you know the background to this? Because we asked for, because we were alleging an appearance of bias, we asked PINs to disclose internal documentation relating to what was going on behind the scenes. Now, that didn't come to us until after, because we requested it under the Environmental Information Regulations, it didn't come to us until after we'd both lodged the claim and indeed the claim had been settled by the consent order. So the content of this is not material that we've ever been able to refer to or deal with in court because it came afterwards. So were you aware of those circumstances?
In terms of the chronology, no.
No, okay,
No.
all right. Well, I'll leave that there. I will come back to it in submissions, but I just wanted to establish that factual position. Now, I want to come to this then, please. We're going to move away from the law, I hope, now. Can I ask you to go to NID 3.7, please?
Yes.
NID 3.7, which is the CMC note from our inspector.
Yes, thank you.
And if you could go in page 2, please, of that document.
Yeah.
There's a heading at the top of the page, main matters to be considered. And then you'll see that underneath, there's sort of 4 or 5 items. And the last one is submission agreement. materiality of previous quash decision, quashed on procedural unfairness, then it records the other grounds, and it says evidence touching on previous decision may be presented by witnesses in the event that I deem it to be material. So I don't know whether, were you probably weren't instructed when this CMC happened, were you, actually, because this was January, correct?
That is correct, yes.
Yeah. So, I mean, as we understand this, and obviously the inspector will know best, the inspector was aware there was going to be a dispute between the appellant and the council about whether the previous decision could be had regard to. And the inspector knew our position was that it cannot or should not be had regard to. But the inspector wanted to be clear that obviously he wasn't going to make a decision about that one way or the other before the inquiry. So he wanted us to deal with the decision in case, of course, he decided against us and thought that he should have regard to it, yes?
Yes.
So we've been invited, haven't we, to put forward our position on the decision, even though we say you shouldn't be having regard to it, correct?
Yes.
Good. Now, I want to understand how your evidence works in relation to this, please. So can we just look, please, at your proof? There are 4 references in your proof I want to pick up, and then I want to come to what you said orally in your evidence in chief. So if we look at your proof of evidence, please, I think the first of the references that I would like to go to is your paragraph 8.2 on page 16.
Yes, thank you.
And on 8.2, you say, I consider the first appeal decision notice, which is less than 1 year old, is an important material consideration so far as the following findings relate to similar issues in this appeal. So just first point to note, you consider the previous appeal decision to be an important material consideration, correct?
Yes, and just to expand on that, that's a professional judgment I've made. The planning landscape hasn't changed. We still have the same development plan in place as previous, and the national landscape provisions in the in the framework remain. And in fact, there's actually a strengthening, I believe, in terms of the provisions within, particularly through the LURA. I was mentioning that several times yesterday.
It's not a strengthening, is it? Because that provision was in force the previous inquiry. I'm going to come to this in detail, but it's not a strengthening, is it? Because the provision was in force before the previous decision.
I think the strengthening comes from the update to the planning practice guidance as well, though, and that's been brought in. And as we know through Mead realisations, that's given equal status now to the NPPF. So I think there is a strengthening, but we may disagree on that.
We do disagree on that, and I'll come to that in detail, but it's not really the point I'm getting at now. Let's just stick to my point. So the first reference here is your position, very clear, crystal clear. You consider the previous position to be an important material consideration on this appeal, correct?
Yes, that's correct.
And then in relation to 8.3 of your proof over the page, at the end of that paragraph, you say on balance and in recognition of the grounds for quashing the first appeal being unrelated to the planning merits of the proposal, I have given significant weight to the first appeal decision. So it's an important material consideration which you give significant weight to, correct?
Yes, that's correct.
Right. And then if we go, please, in your proof to 11.9.
Yes, thank you. How about?
Now, in 11.9, you say 4 lines down, I attribute again, so this is in your planning balance, you attribute significant weight again, don't you, to the first appeal decision? Yes?
Yes, that's correct.
And then in 11.4 on the previous page, you say there are a number of material considerations that weigh against the appeal proposal, and those include, first bullet point is the previous appeal decision, correct? See that? 11.4. Here are a series of appeal that weigh against the appeal proposal, and the first one is the appeal decision, correct?
Yes, that is correct.
So you reaffirmed all of that in chief. It's crystal clear, isn't it, that your planning views on the planning merits have very much been influenced by and taken into account the previous appeal inspector's decision, correct?
No, I disagree with that. I've taken it into account, giving it significant weight, but I thought my own professional judgment.
Well, I mean, let's try and be a little bit fair about this, shall we, Mr. Johnson? I mean, it's repeatedly referred to throughout your relatively short proof. It's said to be an important material consideration to which you attribute significant weight. and you refer to it twice in your very short planning balance conclusion, it is an important part of the reasoning and the conclusions that you have advanced at this inquiry, is it not?
It is an important part,
Yeah.
yes, but just to expand on that, there are other evidence documents that are also important parts, but
Sure,
yes,
sure.
I wouldn't disagree with
Sure,
that. Yeah.
but you see, the inspector has a decision to make down the line about whether he has regard to this previous decision. And from us, he knows our position is he should not have regard to it at all, and that's how our case has been presented. But we've also, for example, Appendix 10 of Mr. Collins' proof, addressed the decision on the alternative basis the inspector decides against us and concludes that he should have regard to it. Your evidence is only written in one way, which is by having regard to this decision throughout your proof. We don't have, do we, an account of your view of this case in a world where we ignore that previous appeal decision.
I wouldn't wish to ignore that decision by any means. And the reason for that is that my consideration, having read that and read the evidence as well, the other evidence documents, I believe that, the conclusions remain relevant.
Yeah, but my question was...
Same development plan, same national, very similar framework.
Well, thank you. Those are the reasons why you've taken it into account, which I wasn't asking you about. What I was asking you about was a much simpler question, which is that suppose the inspector decides that we're right. I know you don't agree with it, but that we're right, and that either he can't or that he really shouldn't have regard to the previous inspector's appeal findings. There is no account by you in your proof of how you would view the merits of this appeal absent that decision, because it permeates all through your evidence, doesn't it?
No, I disagree with that.
Okay, where in your proof then do I see what your assessment of the planning merits is, excluding any reference to the appeal decision? Where do I see that?
Well, there's nowhere in my proof where I've referred to the fact that my views have been entirely influenced by that. I've referred to throughout my proof of evidence I've referred to a number of documents, and that all forms part of the evidence base that has led me to the conclusions I've reached.
No, but you understand my point. Throughout your proof, you refer to this as a very important consideration, gives it significant weight. You refer to it multiple times in the planning balance. Where do I see you setting out an alternative position whereby what you actually consider the planning balance to be, if you strip out this very significant, highly material consideration, where do we see your view expressed? We don't, do we?
Well, perhaps if your question is, am I wholly reliant on that decision?
No.
The answer is no.
That's not my question. My question is, if we do strip it out, where do we see your assessment of what the planning merits are absent that appeal decision? And the answer is we don't see that, do we?
But I think just to respond to that, I think you have to be aware that, I refer to many other documents, such as paragraph 190 of the framework. There's nowhere where I wouldn't say, if you strip that out, I don't think you can draw conclusions along the line you're talking about, because it is an important consideration. I've given it, I've given it a lot of weight, as I have for the framework and the policies and development plan.
Yeah.
So it's all part of the evidence base that's led me to my conclusion.
Well, I know it is, but what I want to, I'll give it one more try. Your planning balance conclusion, crystal clear, your planning balance conclusion has had very clear, significant regard to the previous appeal decision. You tell us so right through the proof. There isn't anywhere, is there, where you set out what you consider the planning merits would be if you stripped that out of your planning balance? Because we only have one planning balance from it. We don't have two planning balances, do we?
No, we don't. But just to contextualise that, there's nowhere where I've referred to if we stripped out other documents or other representations.
No. Well, I think I've got that point. Okay, now, just so I can understand your approach then to this, if we go back to your 8.2, please, of your proof.
Let's see.
I was taken by the words that you used here. You say, I consider the first appeal decision notice, which is less than 1 year old, is an important material consideration so far as the following findings relate to similar issues to this appeal. And I'll come to those similar issues in a moment. But the way I read this is that you're treating the previous appeal decision as if it had never really been quashed. So it's almost like a world where we lost that appeal, we put in a new application for the same development, and we ended up on a further appeal a year on. And you're simply saying, well, look, you guys are just pursuing an appeal for what you've just a year ago lost on. I mean, isn't that really tantamount to what you're saying, that we're treating this appeal decision as if it were a valid appeal decision?
No, I'm treating the decision as it was a quash decision, but I'm just, what I refer to in my proof is that, the conclusions reached by that inspector largely are very similar to the conclusions that would be reached today, because you have as I keep saying, you have the same development plan,
Yeah.
the same framework, and so on and so on. I won't repeat myself.
No, well, don't repeat yourself, because I'm coming to all of those points, and we'll see how good those points are or not in a moment. But I mean, you're not. I mean, you've given it. We know you've given it. It's important material consideration because it's a decision in the last year, significant weight. I don't see any reduction by you in the weight given to that appeal decision. Not one jot. By the fact that it's actually been quashed. Is that right? Effectively, it carries the same weight in your view as if it were a valid decision that had been made a year ago and stayed on the planning record, correct?
Correct, and that is my planning judgment.
Okay, well, I understand that's your judgment, and that's helpful that you've confirmed it. Now, I just want to understand again how that works. I mean, the decision has been quashed, yeah, factually.
Yes.
Yeah. Okay. Now, in evidence in chief, you said, it's very important that the inspector have regard to it because of the principle of consistency in decision making. And you said, indeed, I think you went so far in your evidence in chief to say that there wasn't a public interest or a strong public interest in the inspector here, our inspector, reaching a different decision from the previous inspector when matters are, in your view, come to this, very similar or the same as they were a year ago. Do you remember saying all of that?
Yes.
Now, we argued, and this has never been resolved by the court, that the previous inspector's decision was tainted by the appearance of bias. Yes? Correct? That's what we argued. Yes?
But yes, but just to contextualise that, it was quashed on procedural unfairness.
But I didn't ask you what it was quashed on. I asked you what we argued. We argued,
which was not it was not a planning matter. It was procedural unfairness.
No, we argued, correct, that the decision of the inspector was tainted by the appearance of bias. Correct?
It was argued. Yeah.
It was argued, and it's never been resolved by the court whether that's a good point or not.
I don't believe it was conceded by the Secretary of State.
I didn't ask you whether it was conceded by the Secretary of State. I said it's never been resolved by the court, has it?
No, it hasn't.
No. Good. So that's the position. You're not suggesting, are you, that we should be applying the principles of consistency of decision making and telling us what the public interest involves when there is an outstanding allegation that that previous decision is tainted by the appearance of bias? You're inviting our inspector, aren't you, to adopt findings that we allege are tainted by the appearance of bias and which has never been ruled on, correct?
Just before we get the answer to that, I mean, I just want to be clear, and it may be that Mr. Cosgrove can help here. He said that, I think he said an outstanding allegation.
Well,
It's the word outstanding.
Yes, sorry, not in those proceedings, but the position, I should be clearer, sir. So yes, let me rephrase it, sir. So if our inspector adopts or has significant regard to those findings of the previous inspector, it would be open to us, wouldn't it, to argue in a further challenge that those findings were themselves tainted by the appearance of bias and that they would infect any reliance on them in this decision. That would be open to us.
I don't, with great respect, I mean, any challenge to an inspector decision is on the point of law.
Yeah.
So you're inviting my witness to identify whether your points of law, I mean, I don't think that's within his scope of evidence. He's a planning witness giving his planning judgment.
Well, but he is, you are inviting the inspector, aren't you? Just let's select factual position. You're inviting the inspector to adopt findings or have regard to findings by the previous inspector, yes?
Yes.
Findings which we alleged in the previous proceedings were tainted by the appearance of bias, yes?
Yes.
And findings and allegations which have never been determined by the court.
Yes, and just to add to that, just to add to that very quickly though, the appeal, without wanting to go over old ground, it was quashed purely on one very narrow legal point, procedural unfairness. That's what it was quashed on, procedural unfairness, not on any planning matters.
Well, so I mean, just to understand that, your position then is that we ignore, do we entirely, the fact that there were other grounds of challenge to that decision that have been unresolved? Just so I understand, that's your position, is that right? Because they weren't consented to, we ignore them.
They were, the Secretary of State didn't concede on those points, but as Mr. Cosgrove has just mentioned, I fear that I'm
Okay.
moving into areas of law here, which is
No,
outside
I
of
just
my
want to know,
remit.
your position is, because you've made this point to me a number of times, it's consented, it was only consented to on ground of fairness, correct?
That was my starting and my finish point.
Yeah,
Yes.
I know. So that means, just so I understand your position, factually, so far as you're concerned, we ignore the other grounds of challenge that were not consented to. They're not relevant in your view.
But forgive me, Mr. Marici, I think this is a legal point.
All
I
right.
think you're raising
Okay,
here.
so you don't have a view on that? You don't have a view on that? Okay.
No, I'll leave that
All
to
right.
yourself.
Now,
Mr.
can we then
Cosgrove.
look at the
Thank you.
paragraphs of the inspector's decision that you say in 8.2? You say, I consider the first appeal decision notice less than a year old, albeit quashed, is an important material consideration so far as the following findings relate to similar issues to this appeal. So just before I set off on this, I mean, this is where you have, and correct me if I'm wrong, set out what you consider to be the key previous findings of the inspector that relate to the similar issues on this appeal, yes?
Yes.
Right, good. So paragraph 52, I don't think we need to spend any time on because that's just the inspector identifying the main issues, yes?
Yes.
Paragraph 67, landscape impact.
Yes.
So you say there's common ground between the main parties. The adverse landscape impacts and visual effects would only occur in respect of open land beside Midhurst Road and footpath 597, the fields adjacent to Chiltern Close and Scotland Close, LCA 1, the northern fields by Scotland Close and Scotland Park, which I think that's LCA 2, I think you're referring to there, correct?
Yes, correct.
Yeah. I mean, that reflects, doesn't it, not just the agreement at the last party, but it reflects the agreement at this appeal, doesn't it? The landscape effects are confined to LCA 1 and 2, yes?
Yes.
Yeah. And on LCA 3 to 7, 78% of the site, there's beneficial landscape changes on an agreed position, yes?
Yes.
Yeah. Okay, now you then refer to 118 and 119. Midhurst Road is characteristic of a country or sunken lane within the national landscape. The LVI states around 180 metres of enclosed character at Midhurst Road would be lost. The proposed widening would be at odds with the prevailing character and combined with the proposed felling of semi-mature and mature trees to provide the access and visibility could not be completely mitigated. So, I mean, again, I assume rely on the answers given by Mr. Petro on this, but we agreed with Mr. Petro, didn't we, that in the vicinity of Midhurst Road around the access, the site is not sunken lane, is it?
No, the access meets almost at grade.
Yeah, at
Midhurst
grade,
Road.
yeah.
For that short stretch of Midhurst Road.
Yeah, and then the landscape witnesses have debated, haven't they, whether Midhurst Road, despite not being sunken, is characteristic of a country lane or not. So that's a debate the landscape witnesses have had, correct?
Yes, that is correct. I
Yeah.
have my own view, but yes, that is correct.
Okay. And then the issue is whether the new planting that we propose by way of mitigation would in the end mitigate that, whether the road would ultimately lose its enclosed character. Yes, that's where we get to. That's the debate between the landscape witnesses, correct?
Yes, that was the debate, yes.
Right, that was the debate. Now, just in terms of a couple of things on that, in terms of tree losses, obviously as a matter of fact, this is quite a small point, but I just want to get it out there now. As a matter of fact, 2 of the trees that Inspector Bristow would have been referring to as being lost to deliver the access have already been removed by the Highway Authority, haven't they?
Yes, that's my understanding.
Yeah.
Yes.
And in relation to what you say in your proof about Inspector Bristow's findings in paragraphs 118 and 119, you say he found that the losses could not be completely mitigated, which I think is a fair summary of what he found at the very least, yes? So he found that the impact from the delivery of the access could not be completely mitigated, yes?
That's correct. And I believe that was also a view presented in the landscape visual impact assessment as well.
Right.
For the first application. Yeah.
Now, completely means entirely or wholly. So the inspector's finding, and you say may also be the LVIA finding, we can look at that in due course if we need to, is that the new planting may not entirely or wholly mitigate, but that it could very largely do so.
In relation to mitigating what?
The impact of the
expand on that,
access.
sorry.
Well,
In views.
just look at the language that you're summarising, I think correctly, what the previous inspector said, that with the proposed felling of trees to provide access and visibility could not, so those impacts could not be completely mitigated. So the inference from could not be completely mitigated is they couldn't entirely or wholly be mitigated, but they could very largely be mitigated.
No, I would disagree with that,
All
I'm
right.
afraid. I think the key point here is as well is that when we're talking about views, it's not just from a snapshot point, as the visualizations would suggest. It's a kinetic experience. So you will get views up and down that stretch of 180 metres where the trees have gone. And yes, there is some mitigation proposed. We all know that. There's some hedgerow planting. But what we also have to take into account is that you have a footpath that will be realigned to the inside of that hedgerow planting. So the footpath will sit between the hedgerow and the new driveway through the middle of the site. So that'll be the experience of the users of that footpath. They'll have a road on their right and they have another road on their left, albeit with a hedge in between the two. So that in terms of mitigation, you have to be a bit careful because that's quite a broad. There is also the point as well, is that you'll have a gap in any mitigation, you'll have a gap in planting where that access enters the site. You'll have a wider road, a lot of white road markings, a right-hand turn, and you'll have a wide access with views afforded of the new road into the site. So the mitigation, there is mitigation proposed. I'm not denying that, but it's a partial mitigation.
And a key focal point of that access would be the lodge.
The lodge will be very evident, yes.
And that's the building which Mr. Petro accepted is attractive and of the highest quality design.
I would say yes, but just to contextualise that, it is of a good design. It's just in the wrong place.
Well, you see, I knew you'd say that. A lodge is in the wrong place. Well, where do lodges go? Don't they go on roads by accesses? Isn't that where lodges go? Gatehouses?
It's in a national landscape. And I think if you carry that argument through, what you're almost justifying here is that you would have a lodge. You could have potentially hundreds of lodges all over the national landscape if you carry on
There
that
are
line of
hundreds of
argument.
lodges all over the national landscape, Mr. Johnson. There are hundreds of them. That's what we put in our evidence. There are hundreds of lodges.
So what you're seeking to justify here is you're seeking to justify, because there are examples of historic lodges occasionally. I haven't got numbers, I don't know, but I have seen them and I've seen that in the evidence. But you're trying to justify an uncapped level of development because you've drawn on a handful of examples of lodges in the national landscape. And I don't think that's in line with the framework, or certainly objective to the framework.
Just to be clear then, your position is that the building of any lodge in a national park is contrary to national landscape purposes?
No, I'm not saying that.
No, okay. No. So what does it depend on then, Mr. Johnson, if it's not? So a lodge can be built in a national park and that can be entirely consistent with the purposes of the national park. Is that correct?
National park or landscape?
Sorry, national landscape. Correct? Just a matter of principle. Yes?
I think you have to, each site is judged on its merits.
Do you accept that a lodge could be built in the national landscape, which would be entirely consistent with the purposes of the national landscape? Yes or no?
In exceptional circumstances, and I think that would take you to paragraph 190.
Okay. So it's not your case to say then that simply the provision of a lodge, if for example it was attractive and well designed and in accordance with the local characteristics, that's not per se going to be in conflict with the purposes of the national landscape.
I don't think you can use design in terms of the wrapping you're putting around this built form to justify development in the national landscape unless there's exceptional circumstances justified. I think you're bringing design into the discussion here, which
I certainly am, but I just wanted to be clear about this because, I mean, this is really crucial because I think what you're doing, we may be jumping on to the next part of your proof, is if you look at your next part of your proof, where you deal with what Inspector Bristow said at 121 and 122, you say the proposed intensity of built form close to the proposed access would clearly be at odds with the natural and scenic beauty. Consequently, the proposal would fundamentally and seriously adversely affect landscape and visual character. Now, this is where we say Inspector Bristow went fundamentally wrong, and I put the GALD and all that stuff to Mr. Petro. But I just want to look at the wording there. You're saying that the intensity of built form, do you include the lodge in that?
Yes.
Right. So the lodge would be clearly at odds with the natural and scenic beauty. So just so I can understand it, your view is that any built form of any scale, really, is going to be at odds with natural and scenic beauty because it's not natural or scenic in your view.
No, and just to add to that, we're not talking about an application just for a lodge here, are we? We're talking about an application for 100 other dwellings. There's a road that's going to be widened. There's a new access. There's a rear line footpath, the car park. There are other buildings involved here. So we're not just talking about a lodge.
No, we're not.
That's where we're.
But how many of the 110 houses would one see from Midhurst Road? From the access, from walking along that?
Not from the access.
You'd
but
see
you
none.
certainly would see them from the footpath as we
From the corner point that we talked
Yes,
about
that's
earlier.
correct. Yes.
But from this access point, you know, what you would see, the most prominent thing you would see is the lodge. It's the key focal point, I think Mr. Petro accepted.
No, I would disagree with that
All right,
because
disagree with that.
you have a road that is for a large part sunken. It's very
All right.
characteristic. You're changing the character of that road, removing trees, opening up the view. You're widening that road.
Mhm. So could we then look at, remember, we just looked at what you said about Inspector Bristow's 121 and 122.
Yes.
Could I please look at Inspector Bristow's decision? So this is NID 3.8. And I'd ask you just to flick through to get to paragraph 121.
Just bear with me. Sorry, what was that paragraph?
121 and 122.
121, 122. Thank you. Yes, I found that. Thank
So
you.
these are two of the paragraphs that you've specifically drawn attention to. Before we get to 121 and 122, there's 120, which I discussed with Mr. Petro. I just want to touch on some points with you in relation to that. So the third line down in 120, he says, I acknowledge the gatehouse would emulate gatehouses found throughout the AONB. So in relation to the discussion you and I had a moment ago, Inspector Bristow's view was that what we are proposing to build would emulate gatehouses that you can find throughout the AONB. And that is true, isn't it? And we've put evidence in of many others, correct?
That is correct in
Fine.
terms of that very small part of
Okay.
the overall
All
scheme.
right,
Yes.
fine. And then he goes on, architecturally, it bears much similarity with the lodge formerly associated with Red Court. Fine.
Mhm.
However, I question the use of the word landscape in the LVI phrase. As reasoned in paragraph 78 above, the AONB was designated as regards natural beauty rather than for its built environment. So I put this to Mr. Petro. I just want to understand whether this is what you're advocating. The suggestion here, as I understand it, appears to be that built form is per se inconsistent with designation for natural beauty. Do you agree with that or not?
I'm not denying the fact that there is built form within the national landscape.
Yeah, but that's not the question I asked
Existing
you.
built form.
That's not the question I asked you. The question I asked you is whether you agree with the sentiment that is set out in 120, that built form, however good its architecture, however characteristic it is of the other architecture in the national landscape, that such built form is inconsistent with natural beauty, because it's not natural.
No.
So is that your view? You agree with that, do you?
I'm just trying to, if I may, I'm trying to follow your question here, but you're referring to, you have built form, then you have natural beauty, and the two are obviously very distinct because you can't have, by its nature, built form isn't natural.
Well, you see,
So-
that's exactly what Inspector Bristow said and exactly what we say he got completely wrong. Because when you look at criteria like GALD, which I showed Mr. Petro, the natural beauty criterion as defined by Natural England includes looking at built form. Built form can be part of natural beauty. But you think that's, just to be clear, and this is why I'm asking you, you don't agree with me on that. You agree with Inspector Bristow, correct?
I'm just struggling to understand how something that's built can be also be considered.
Well, take it up with Natural England. Take it up with Natural England. It's their guidance. But all I want to understand from you is, you agree with Inspector Bristow and you disagree with me. You think that built form is the antithesis of natural beauty.
No, I'm not saying that. No.
Okay, good. What are you saying then?
Well, I don't think you can refer to built form as in all the same. Built form has very many different shapes, periods,
Well, that's not answering.
appearances.
We know what
Built
built form we're talking about, you and me here, because we're looking at paragraph 120 of the inspector's decision. He's talking about the lodge. Characteristic of other lodges, fine architecture, highest quality design. Inspector Bristow, nonetheless, despite all of those positive findings about the lodge, thought that built form, even of that quality, of that nature, was the antithesis of the natural landscape. Do you agree with him that even that most beautiful, characteristic, architecturally fine built form is not part of natural beauty?
I think you have to contextualise that, because obviously what Mr. Bristow was dealing with here was a site that at the moment where that building's proposed is it's completely open, it's green, it's a sweeping area of grassland.
Yeah, but
And I think that's where I think you need to contextualise that a little bit.
No, I don't think we do. I think what we need to do is try and see if you want to. I'll give you one more chance. I don't really mind if you don't want to answer it after that, but one more chance. So it's very clear. Inspector Bristow makes a number of very positive findings about the lodge. We know Mr. Petro agrees that it's a fine building, but the inspector nonetheless says this AONB was designated for natural beauty rather than built environment. So he does not see even this fine piece of architecture, characteristic of other lodges, he does not see it as being something that can be considered as part of natural beauty. Do you agree with that or not?
I do agree. It's
Right.
just in the wrong place.
Okay, the wrong place for a lodge. Where does I mean, just to be clear, you said that a couple of times. I mean, we don't put lodge gatehouses in towns, do we? That's not where they go.
I can't answer that, but
You don't know where.
I don't.
Well, you can answer it. You just told me that it's in the wrong place. If it's in the wrong place, what's the right place?
Because the wrong place being is that this is a characteristic part of the national landscape.
So
And at the moment it's completely
Well, we'll go-
open. It's
Right.
behind it's part of a sunken lane. It's a very attractive sweeping area of grassland, and that's my starting point. That is the context for that building.
But that's taking us back to a position that you said wasn't your position. Your position was not, you said, that a lodge built in the national landscape would always conflict with the purposes of the national landscape.
No, I wouldn't draw. No, not in every circumstance. But I'm going back to context.
What
The
circumstance?
context of this site.
What circumstance would it be acceptable?
Well, it may be it may be acceptable in the national landscape if exceptional circumstances are justified. It may be acceptable outside of the national landscape, but I can't comment on that because every site has its own context. And you have to start with context.
Okay.
The National Design Guide is very clear on, and the context of this site is that you have it's a national landscape designation. You have an attractive open area of grassland that is characteristic of the Surrey Hills national landscape. And
Okay.
that goes back to my point that it may be a beautiful building. It might have a nice bit of wrapping paper around it to make it look attractive,
Well,
but it's just in the wrong place.
I'm sorry, but just to be clear on that, I mean, a bit of wrapping paper around it. I mean, I just ask you to consider that evidence because we know Mr. Petro's agreed that it's an attractive building. And we know the council's position is that the design of that building is of the highest quality. So it's slightly offensive, isn't it, to simply say that it's got wrapped around with wrapping paper. It is a fine building on any review, and that's not disputed.
My
Correct.
position on that
Is it a fine building?
Well, as a chartered planner and a qualified urban designer, it's an attractive building. It has some
Right.
design embellishments, but that doesn't
Okay.
override the fact that it's in the wrong place.
So, yeah, I know we keep coming back to this, but I just want to see if I can just get to the bottom of this. So if you have an area anywhere in the national landscape that you regard as characteristic of the national landscape and as being currently open and green, you would say no to built form unless you meet the exceptional circumstances test.
Yes. Right.
But I mean, that's just to be clear for a moment. That's entirely wrong as a matter of planning policy, isn't it? Because suppose I was just applying for the lodge, yeah? I wouldn't have to meet the exceptional circumstances test, would I? It's not a major development.
Excuse me if I could just ask a bit of clarification. How are you defining major development? What, I mean, are you,
Well, I'm telling you, you don't have to believe me, one unit in a national landscape is not major development.
I think,
So just, that's correct, isn't it?
well,
You don't know.
I don't, well, it's not that I don't know.
Oh,
I think we're in disagreement because you have to take, the national landscape is on an equal pegging now with national parks and the Broad. It's at the highest sensitivity. Now, if a client was to approach me in my practice and say, I'd like to put a building in the countryside in a national park, I would be advising them to be very, very careful with that because it's unlikely you'll get a local consent. And that's you know, you might end up at appeal. But this is a situation here where you have a national landscape. Not only that, the site's very characteristic of that national landscape. And you're proposing built form.
I'm sorry.
On a site that's completely open at the
You're
moment.
moving far away from my question. And my question is quite straightforward. For example, have you looked at the recent officer report on the Hedgehog Lane scheme, the one that you talked about yesterday that was pulled as an application at the last moment? Have you looked at that officer report at all?
No,
Mr.
I haven't. I have not read the
So
report. No.
I think that's for 14 units. Is that right? 14 units. That's not considered by the council to be major development. And that's consistent with the approach of planning authorities right across the country that really that number of units is not enough to be considered to be major development. Now, just bear with me on this. Suppose I'm right, which I am, that a single lodge would not be major development. If something's not major development, there is no exceptional circumstances test, is there? Correct? As a matter of policy.
Can I, in answering that question, and I apologise, it's very difficult to give a yes or a no, but I don't believe you are correct. I think if you go to footnote 67 of the framework, so if I can refer you to that, well, I think it's on page 55. For the purposes of the framework, for the purposes of 190, paragraph 190, which is what is the crux of this, what we're talking about here, that goes to the heart of what we're talking about. What is a major development? It refers to very clearly in footnote 67. It's a matter for the decision maker to take into account, and I'm quoting here, nature, scale and setting, and whether it would have a significant adverse impact on the purposes of which the area has been designated or defined. So I don't think you want to, I think there's a little bit of danger here that you're confusing what major development is in terms of planning decision making, 10 dwellings or more.
No, I'm
and in terms of what's in the footnote, with all due respect, in footnote 67.
I'm absolutely not. And we're going to come to this when we look at some of the other appeal decisions. But I just want to be sure, have you got, we've got lots of appeal decisions before us. Have you got any examples of either officer reports from this authority or appeal decisions? We've got so many of them, where anything like one unit has ever been considered to be major development in a national landscape?
I don't have an example.
No, you don't.
It's just my
You don't.
professional view.
All right. Now, just to understand this, I just want to come back to this, and we're going to take a break, I think, then, but your exceptional circumstances point, I just want to make sure I understood this with you. As I understand what you're saying to me is that if you've got an area characteristic of a national landscape that's currently open and green, your view is that a building that's proposed, however attractive, would only be acceptable in your view if there were exceptional circumstances. Am I right that that is your position?
That is my position.
Good. I'm glad that's your position. Thank you. Noted. If the exceptional circumstances test did apply, the quality of the design and the architecture and whether what was proposed was characteristic of other buildings in the area, that would be relevant to exceptional circumstances, correct? Relevant to exceptional circumstances.
No, I disagree with that, and to explain why. Design is an important matter. Of course, it is in planning terms. We know that it has been for many years, but design was, as we referred to, we dealt with this with the landscape witnesses. Design was baked into the landscape visual impact assessment. The assumption there from the get-go, from the starting point, was that this scheme would be of the highest quality design. So that's always been factored in. And then obviously as the LBIA worked through and its conclusions drawn, so design has always been taken as read as high quality anyway.
It's not answering my question. I want to be clear on this. I want to be clear on this because, I mean, I'm going to have to be suggesting to you in a moment that your understanding of exceptional circumstances is looking a little bit insecure here. So let's just make sure we understand it. Do you accept, and there is Court of Appeal authority we've got in the bundle, that all of the benefits of a scheme may be had regard to in considering whether there are exceptional circumstances for a development in a national landscape?
Yes.
And that does not include design. The fact that something is a excellent design, highest quality design, meets the local architecture characteristic of the area, that's not something you can have regard to as a positive under the exceptional circumstances test. Really? Are you sure?
That is my view.
But I mean, that's, and you've not sought to calibrate that view against any of the appeal decisions or Court of Appeal decisions which have looked at what exceptional circumstances take into account. So far as you're concerned, exceptional circumstances cannot take into account the quality of the design. That is your evidence, right? I just want to be clear. I mean, I'm happy to make submissions on where that leaves you, but is that your position?
I think we just,
Yes
no,
or no?
I'll go back, well, no, I'll go back to my point that exceptional high quality design was baked into landscape visual impact assessment. And that is where I go to when considering exceptional circumstances, the conclusions of that study, and of course the evidence of the landscape witness.
Just not relevant to my question, but I'll try one more time. Just so I'm absolutely clear, the way I will deal with this in closing is to say that your position is that you don't believe that if one was considering the exceptional circumstances test in the NPPF, you don't believe that design is relevant to that consideration.
Not under paragraph 190, no, I don't. Unless there is, I mean, the framework does deal with exceptional design, doesn't it, in paragraph 84, where it refers to buildings of exceptional quality in the landscape. But we're talking about paragraph 190, obviously, here. So the answer is no.
I'm sorry, but your evidence on paragraph 190, which we'll come to, is that it's not exclusive to those matters. That is your own evidence, isn't it? It's not exclusively limited to matters A, B, and C. Yes?
No, it's not.
Right. So why is design excluded then?
The design is excluded because it's already been factored. I think you're doing a bit of double counting here because it's factored into the landscape visual impact assessment from the start. So I think you're adding design on top of a discussion that's already been settled through the landscape visual impact assessment from the start.
All right. Well, so that's probably a convenient moment to take a break. I haven't quite finished with Inspector Bristow's decision, but nearly have. So
Okay, but we're done on that point. On that point. Okay, yeah, that's a useful time to take a break. Let's resume, please, at 11:30.
Just in the context of, we're talking section 106, we did agree yesterday with Mr Marici that if there's discussion on certain housekeeping matters, that would be acceptable. Is that okay with you?
Yeah, I think we probably.
Is it worth waiting till the inspector's back in the room?
Let's wait till being back in the
All
room.
right.
What kind of housekeeping are we doing?
I haven't got any update. I was just going to check if there was anything.
Oh, right, yeah.
I needed
Well,
to chase
things can't come through Mr Johnson, I don't think, so you need to have some other
That's true.
Okay.
other route of contact. Because you can't be talking to other people in the team about what's going on.
No, okay.
Tom might be a good start.
Yeah.
Thanks, Liz.
Okay.
Thank you.
No worries. I wanted to check I was okay.
Yeah, sure.
Yes, yeah.
Yes, I spoke to James last night, he can speak, right, it's exactly, it's 6 or 7, right, yeah, that's fine. Yeah, okay. Okay, 11:30, let's resume, please, Mr. Marucci.
Thank you. Mr. Johnson, I said I'd finish with this design point, but I'll just come back to one thing on it, please. Just so I understand where you're coming from on this. I mean, you accept, I think, don't you, that in design terms, the council are not alleging any breach of its design policies in the plan. I think it's TD1, correct?
Yes, that's correct. It
Yeah,
didn't
so-
feature as a reason for refusal.
Yeah, so the scheme is compliant with local design policies. Yes, that's not alleged. That's not a part of the council's case to allege otherwise, correct?
That's correct.
And similarly, I mean, there are other documents that deal with design matters, like, for example, the Surrey Hills Environmental Design Guide and indeed the management plan, which has design policies. And again, it's not been part of the council's case to allege any breach of the design parts of those documents, has it?
No, that's correct.
No. So can I then ask you to go to the MPPF, please, which is in CD 8.1. You may have your own copy.
Yes.
Electronic, page 41, paragraph 139. So
Yes.
139 is kind of in two parts. So the first part is development that's not well designed should be refused, especially where it fails to reflect local design policies and government guidance on design, taking into account any local design guidance and supplementary planning documents such as design guides and codes. So that's not this case because that's not the council's case to allege that there is a breach of any of those, correct?
That's correct.
And then it says, conversely, significant weight should be given to A, development which reflects local design policies and government guidance on design, taking into account any local design guidance and supplementary planning documents such as design guides and codes. So it's quite clear, isn't it, that because we are compliant in design terms with local policies and guidance, that significant weight should be given to that matter in the overall planning balance, yes?
No, I disagree with that. Fundamentally disagree with that. If you carry on reading the paragraph 139,
Yeah,
go to criteria B,
yeah.
the tail end to that sentence refers to so long as they fit in with the overall form and layout of their surroundings. That's the key issue here.
I'm sorry, Mr. Johnson. Could you just look at the punctuation and the wording at the end of A? Significant weight should be given to A and or B, right? So we are fully compliant with A, correct?
Well, I think you can interpret A in terms of local design policies, and it refers to design guidance and supplementary plan documents. Landscape context does come into this whole discussion over design. So I think you have to be a bit careful about, yes, it may in its own right be an attractive building, but you have to take into account the context here of where it is, the national landscape.
This really shouldn't be taking this course, but let's go through it in detail. Does the proposed development, in the council's view, reflect and comply with local design policies in the development plan? Yes or no?
Yes, it does. Yes.
Yeah.
In terms
Does
of the
it-
design of the building itself,
Uh-huh.
yes.
Does it comply with government guidance on design? So Mr. Pullen has gone through compliance with the National Design Guide. The council doesn't suggest that's wrong, does it?
It doesn't suggest it's
No.
wrong, no. But
Good.
just to add a bit of context to that, the National Design Guide does very strongly refer to context as a starting point for making design judgments, design assessments, and as part of context, landscape is
Yeah.
part of the
Okay.
context
Yeah.
of all developments, where it's landscape, townscape. The surroundings of
Mhm.
the built form are part of that context to be taken into account.
And there has been no suggestion by the council of any breach of local design guidance and supplementary planning documents, because you don't make any case on the Surrey Hills Environmental Design Guide, and on the management plan, you don't allege breach of any of the design policies in the management plan, do you?
I do believe it's in breach of the two of the policies in the management plan.
They're not the design policies in the management plan, are they?
The P1 and P2.
Yeah, they're the planning policies, but there's
The planning
design
policies.
policies. You're not alleging any breach of the actual design policies, are you, in the management plan? No.
No.
Now, if that means we comply with A, which we do, it says significant weight should be given to that. And B is a separate point. That's an and or. So if we comply with A, that should carry significant weight, shouldn't it, in the planning balance?
I don't think we're going to reach agreement on this. I think we've got design. I've given limited weight to, and part of the reason behind that is that the starting point for the landscape visual impact assessment, the starting point for the assessment from a landscape point of view has been on the basis that a good quality design is taken as read. That's the starting point. So I wouldn't want to double count on benefits here.
No one's double counting. I think what you're doing is not counting at all, because look, those words and or, they're very clear in their meaning, aren't they? You do not have to comply with both. Do we agree on that? And or is a very clear piece of language. You do not have to comply with both.
We do agree on that, yes.
Good. So if we comply with A, if we do, and I'm not really at this point too interested whether you think we do or we don't anymore, but if we do comply with A, that should carry significant weight according to what's said in the NPPF.
But I don't think we do agree
I
on
know,
that.
I take your point. You say we don't, but we've been through compliance with the local policy context. Okay, let's move on to the last couple of things from Inspector Bristow. So this is back to your proof, page 16. We've been looking at 121 and 122, which is your third bullet from the bottom, penultimate bullet on this page. 124 and 142, housing land supply position. It's common ground between the main parties that the council cannot demonstrate a 5-year housing land supply. The inspector arrived at around 3.9 years supply. So I'm going to come, obviously you won't be surprised to hear to all of this in a lot more detail, but the factual position is that the housing land supply position in this borough is now worse than it was when the inspector determined the appeal, correct?
Yes, correct.
And would you agree with me in going from what the inspector said was 3.19 years supply down to 1.28 years land supply? That is a significant decrease, correct?
It is a significant
Yeah.
decrease, and I don't need to remind you, I'm sure, with the references made to the housing delivery test and how well the
Well, I'm coming to that.
delivery.
Yeah, I'm coming to
That
that,
I'm
believe
sure
me.
we are.
I'm coming to that, believe me.
Yes.
Coming to that, believe me. Yeah, okay. So the housing land supply position, on any view, has worsened significantly since the inspector decided the previous appeal, correct?
It has worsened, but
Yeah.
just to put it into that a little bit into context, it's not as though it was originally close to
Right.
5 years. It wasn't like 4.8, 4.9.
Yeah,
It was always well below
yeah.
that,
So
that threshold anyway.
so that's
We're just a
mitigation.
little bit further away now, but
Yeah.
it was always
Yeah, so that's the
significantly below
mitigation, is
anyway.
it? It was pretty bad, very bad last time, but it's now really, really very bad. Is that mitigation for that point? Is that what you're saying? Kind of lessens the impact? It's gone from bad to terrible? Is that mitigation?
I'm not going to, yeah, I'm
No.
not going to argue
Right.
against
But
that.
you-
It's a poor housing land supply
Okay,
situation.
cool, all right,
yes.
thank you, fair. Now, 156 and 157, Sang, common ground between the main parties that by virtue of the proposed Sang, there would be no adverse effect on the ecological integrity of the SPA. So pause there, that's all agreed, we don't have to worry about that bit. But then this,
Yes.
although this was not considered to be a benefit per se by Natural England, as it may be unnecessary by location development elsewhere. Now, just to take this in stages, and I will have to come back to some of this later on benefits, but you actually acknowledge, don't you, and you made this very clear in your evidence in chief, you acknowledge the Sang provision here as a significant benefit, don't you? You give significant weight to it as a benefit.
Yes, I do, yeah.
Yeah, you do.
Yes.
Yeah. Now, I want to understand that with you a little bit more later on, but can I just broach this with you? I mean, to the extent that the Sang is simply mitigating the impact of our site itself, that's not in itself, is it a benefit? That's just mitigation of our impact, yes?
No, it's a significant, it's a
Okay.
benefit. It's a significant
But-
benefit.
Is it not also part of the benefit that you recognise in your proof, not just that we mitigate our own impact, but that our Sang is large enough, whether it's 9 or 12 hectares, to mitigate other development? Do you recognise that as a benefit?
No, well, that's not where I was going with my weighting.
Right, so
I think I was just going back to my table, vision of open space and Sang significant, because at the point at which I drafted my proof, the section 106 wasn't actually committing to any additional SANG
Yeah, it was.
elsewhere anyway.
No, I'm sorry, it was.
There was no, well,
No.
my reading of the clause in
No,
Schedule
you-
3 was there was no commitment to delivering the SANG.
No, that's completely wrong, completely wrong. It's a complete misunderstanding of the position because at the last appeal, the 106, even if we build out the smaller SANG, that has the capacity to mitigate a large number of other schemes. If we build out the even larger SANG, then their capacity goes even further and the distance goes further. So all the way through, we've always been committed to a SANG that will go further than mitigating our scheme. The only question is, how many additional units? A couple of hundred or 400 extra units? So you're wrong on that, as a matter of fact. Now, I just want to be clear on this. If it's right that we are committing to SANG that goes beyond mitigating, but allows mitigation of other sites, that itself must be a significant benefit, mustn't it?
Yes, it is.
Yes,
If,
it is.
Yes.
If then, okay, I'll take the if, that's fine. Now, the other thing is, just in relation to the inspector's conclusions about SANG last time, can I just ask us to note, when we looked at the grounds of challenge to the inspector's decision, I know they were not the ones that were consented on, but one of our grounds of challenge was the inspector had misunderstood Natural England's advice, correct? That was factually one of our grounds of challenge. Yes?
But not conceded.
Not conceded, but that was one of our grounds of challenge.
It was, yes.
Yeah. And have you looked at Mr. Kite's statement, which is attached to our ecology proof, and which includes some of the recent correspondence with Natural England?
Yes, I have.
And have you seen that they've recognised that their previous representation, which the inspector relied on, they accept could have been misleading, and they have given different and fuller views this time round, yes?
Yes.
Yes. So in terms of looking at what Inspector Bristow said on this particular point, we do have to have regard to the things that have moved on and changed, don't we? Yes?
In terms of
Natural England's position.
Natural England's position.
Yes. We have to have regard to that, don't we?
We do have to have regard to it,
Okay,
yes.
good. Excellent, thank you. Now, yes, so I think the final paragraph, if we go over the page on your proof to page 17, is the conclusion that you refer to. The inspector concluded the proposal result in fundamental and serious harm to the landscape, and exceptional circumstances had not been demonstrated despite benefits put forward by the appellant. So that was, of course, was Inspector Bristow's conclusion. That language that he uses, fundamental and serious harm, Mr. Smith's evidence when he was cross-examined was that's not, is it, that phraseology, the language of Glivia, correct?
Correct.
Yeah, okay.
I'm not sure if I don't think the inspector was a landscape architect, the inspector was a planner, and I think
No,
that's a planning
Okay.
reference rather than a landscape
All right.
architect terminology.
Okay, thank you. Good. Now, if we are considering the overall harm to the national landscape, and I know we've sort of touched on this already, but can you just ask me, I wonder if you can help me with these, whether you consider these matters to be relevant considerations in considering the level of harm. The landscape witnesses agree that the appeal scheme in the wider landscape, so not in views immediately around the site, but in the wider landscape, is largely invisible. Is that a relevant consideration?
Yes, it is
Yes.
relevant.
And it's also agreed, isn't it, that the 110 houses on LCA 1 and 2, with the exception of the point that you've taken me to a number of times on the footpath, is again largely invisible, yes?
Yes, I believe we're agreed on the localised, but permanent, but localised nature
Permanent
of
but
impacts.
localised, yeah, thank you. Thank you very much. We've also seen, haven't we, that in terms of visual rather than landscape impact, the position that we get to at 15 years, according to Mr. Petro, is slight on all the visual receptors, yes?
Yes.
That's a relevant consideration also, isn't it, to landscape, because landscape has a visual aspect, doesn't it? It's
Yes.
not entirely visual, but it has a visual aspect, yes?
Yes, correct.
Okay. Now, when we come to look at exceptional circumstances later on, do you accept that the relative lack of visibility of a site that's proposed for major development, 111 houses, the relative lack of visibility of that site is a relevant consideration under exceptional circumstances. I'm not saying it's decisive, but relevant.
Yes, I wouldn't agree there's a relative lack of visibility because it's highly prominent, albeit from a localised point of view. It's a
Well,
highly prominent development.
so the fact that it's not visible or not materially visible in the wider landscape, yeah.
Yes.
The fact that there are actually pretty limited local views of the housing, apart from the one point you're drawing our attention to, yes, those things are relevant, aren't they, to exceptional circumstances?
Yes.
But yes, good. Well, they must be, because when we come to it, 190C gets you to look at how much landscape visual harm there is and how much it can be moderated. Yes.
Yes.
Okay. Good. Now we'll come back to some of that in a little bit more detail. Now I want to just go in your proof, please. If you go to 8.3, this is a point that you've made to me several times today, and I need to tackle it with you now. You say further to the decision of on the first appeal, there's been no change to the status of the policies of development plan that are most important to this appeal, to the framework or the PPG that I consider would have changed the inspector's conclusions. There's now a strengthened duty on the relevant authorities, and you refer to the Act, and you say on balance, and in recognition of the grounds of quashing, which I'm not going to go back to, being unrelated to the planning merits of the appeal proposal, I've given significant weight to the first appeal decision. Now, what you say is you don't think there's been any change to the status of policies in the development plan or the framework or the PPG. And I'm going to come to all of those in due course. But can I just ask you, I mean, the national policy position has changed quite significantly, hasn't it, from the election of the Labour government and their objective of building 1.5 million homes. That is a change in the national position, isn't it?
In answer to that question, the answer is yes, there has been a change, but there also has been a significant change in how the government intend to deliver on that objective, because obviously what they do have, you've got greater flexibility on Greenbelt. They haven't introduced greater flexibility on national landscape.
No, I'm going to come to that in detail, believe me, I will. But there is the election of the Labour government, the agenda that they have set out to build 1.5 million homes within 5 years of their election. That is a fundamental change in the national landscape, not the national landscape itself, but in I shouldn't use that word, really, should I? The national policy context more generally. Isn't it a fundamental change?
It is a fundamental change,
Yes.
but it's not at any cost. And I think
No,
that's the key issue here, isn't it? They're very clear. The government are very clear. And I referred to yesterday, if I may, to the ministerial statement. That again, that was reinforced that the government are very clear about introducing new safeguards to make it clear where the presumption does not apply. So yes, there's a strong emphasis on housing, but it's not at any cost.
Okay. No, not any cost, and we'll come to that in more detail. Can I ask you to go, please, to Mr. Collins' appendices to his proof, and it's Appendix 2, which is the Tetlow King report.
May I have a?
Do you want an electronic?
Yes, please.
Oh, I see. It's NID 5.1 is where it all is. And are you going to want an electronic?
Yes. No, sorry, I was thinking it was a separate NID. So I'll scroll. Do you know which PDF page number?
I don't, but let me just
Quite a
find
lengthy,
out.
very lengthy.
Yeah, I can find out. It's going to be.
I think I'm getting there. I've got 1, 2, 3. Is that right?
Possibly. Have a look. Oh, 1, 2, 4. We think. Hang on. So can you find electronic page 1, 2, 3? Have you got it electronically or hard copy?
I have it electronically. Thank
So
you.
if you go to electronic 1, 2, 3, that's the first page. And then if you go onwards in that document to page 1, electronic 129, it's numbered page 3. there should be a paragraph 1.14.
Yes, thank you.
Okay, so this is just referring to one of the many ministerial statements that there have been since the previous inspector decided this case, and there's obviously a reference to the 1.5 million homes, and then we'll see in the quotation, just to see what it says, this government's inherited an acute and entrenched housing crisis, average new homes out of reach for the average worker, housing costs consume a third of private renters' income, etc. And people in temporary accommodation at a historic high, refers to the number of new homes. And it says, as we set out in July, mandatory method is insufficient. If the method itself is not adequate to meet the need, consulted on an ambitious revision to the standard method, increasing the total national target, ending the reliance on decade-old population projections and removing the arbitrary 35% urban uplift. And this is instead the new method relies on a baseline sort of percentage of existing housing stock levels to better reflect housing pressures right across the country, and uses a stronger affordability multiplier to focus additional growth on these places facing the biggest affordability challenge. So when we come to look at the standard method in a minute and the impact it's had on Waverley, one of the reasons why Waverley's standard method number has gone up so much is because the new figures reflect the severe affordability problems that there are in Waverley, i.e. income versus average house price, yes?
Yes.
Yes. And if you go over the page, we heard through the consultation our method could go even further in targeting growth to those places where house prices are most removed from local incomes. Now, pausing there, two things. Waverley is one of those places, isn't it, where house prices are most removed from incomes, because it's got one of the highest affordability ratios, hasn't it?
I'm not sure where it is, but I've
Certainly
assume
high.
that's- but it's certainly high.
Yeah,
Yes.
certainly high. Okay.
Yeah.
And so we've made an adjustment to the method to make it more responsive to demand pressures. The final method now incorporates an even stronger affordability adjustment. And we'll come to this in a moment in detail, but as between the draft standard method in July and the final one in December, Waverley's numbers actually increased, didn't they? The government actually pushed them up even further, didn't they?
Yes, they did. Yes,
they
and
did.
at that point, I believe the authority commissioned a report by Iceni, I think.
Yeah, yeah.
Somebody
We'll
undertook
come to that. We'll come to that.
We'll come to
Yeah,
that in a minute.
we'll come to that.
Yes, it's relevant to this conversation, I think.
Well, it's relevant to this conversation, except it was submitted, wasn't it, as part of Waverley making representations against the standard method that was being proposed in draft, yes?
Yes, please so.
And the government's response to, and we'll look at Waverley's objection, the response to Waverley saying this is not credible number of houses for you to ask us to build, which is I think what the leader said, was the Secretary of State up the numbers further. Yes?
Yes.
Yes. Okay. Well, we'll come to that in a bit more detail. Thank you. So you also referred yesterday, didn't you, to NID 7.1? Could we just go and have a look at that, please? That's one of the July ministerial statements, and you, I think, took us to NID 7.1.
Yes. Yes, I did. Yeah.
And if we, I think that, correct me if I'm wrong, but I think on the second page of that document, you took us to, I think it's the penultimate paragraph, where there is a discussion of effectively green belt, grey belt, and we'll come to that point, which I know you want to talk about and we will talk about. But the beginning of that paragraph that you took us to starts with, doesn't it? We cannot wait for all release to come through plan making. So that's the start of that paragraph. And then I agree with you, and we'll talk about this in more detail. They then start talking about green belt, grey belt, etc., don't they? Yes?
Yes. Yeah.
Okay.
Yes.
Thank you. And then if you go to the top of that document on page 1, again, I mean, in terms of the sort of things that are being said here, in the third and fourth paragraph, very similar to the December statement we saw, the government is telegraphing there, isn't it, in very strong language, just how acute the housing crisis is and just how keen they are to build 1.5 million homes. Is that a fair summary?
Yes, it is. But just to add to that, what the government are also doing, as you know, they're putting the highest level of importance on the need to conserve and enhance the national landscape as well.
I'll come to that.
They've got that at the top of their agenda as well.
I mean, this document itself doesn't mention the national landscape one way or the other, does it? Does it?
No, it mentioned, obviously it mentions the green belt, grey belt.
Yeah.
So that it does go to, in
Right.
terms of how to address that need, how you should do
Okay.
it. But yes, in that regard, no, it doesn't mention national
Okay.
landscape, no.
So there has been, hasn't there, on any view, a significant change in the national planning agenda between the previous appeal decision and this one. This is not business as usual, is it, that the government's talking about in terms of?
No.
No. Okay, good. Now, could we then focus on the NPPF itself? Because when we looked at your proof a moment ago, when we looked at paragraph 8.3, you specifically make the point that you don't believe there have been any significant changes in relation to the NPPF between the previous appeal and this appeal. And I want to just explore that with you. So first of all, can we look at your proof at 7.15?
7.1.
7.15. Third line down, you say, in a case where no exceptional circumstances demonstrated through site assessment, there would be a, I think you mean strong rather than strong reason for refusing a proposal in terms of paragraph 11D1 of the framework. So just to be clear on that, that is something that has changed between the previous NPPF that the Inspector Bristow had before him and the current one. The language in this part of the NPPF has changed from clear to strong, hasn't it?
It has changed from clear to strong, yes.
And just to understand why that's happened, if you go to NID 7.4, please.
NID 7. Yes. Have a part 1 and a part 2.
Sorry, hang on. NID 7.4.
Sorry, NID 7.4. NID 7.4.
It's the government's consultation response.
Response document, yes.
Mine's just crashed out, so let me just go back to, oh, here we are. Right, that's better. I think it's electronic page 14. Yes, if you go to the very bottom of electronic page 14.
Yes.
A change has also been made to be clear that when assessing whether areas or assets of particular importance provide a reason for refusal, there should be a strong basis for doing so when assessed against the policies in the National Planning Policy Framework, replacing the existing clear reason. This reflects views we heard about opportunities to strengthen the presumptions wording in the context of the government's commitment to increasing the supply of homes, but still enables these key protections to be fully considered and enforced where it's appropriate to do so. So the reason for that change is the government are deliberately intending, aren't they, to strengthen the presumption?
They are, yes, they are. But obviously, as part of the presumption is footnote 7. That remains as part of that. That paragraph.
It does, but this is about when footnote 7 policies will disapply the presumption. It used to be if they provided a clear reason for refusal. It's now when they provide a strong reason for refusal, and the intention is to make that a higher test for disapplying the presumption. Yes?
But wouldn't you also suggest it's a higher test for applying footnote 7 as well? Because you read the paragraph as a whole.
No. I'm sorry, you're misunderstanding the government's change here, and I think we need to get to the bottom of this. Footnote 7 is about when you have policies that if they provide a reason for refusal, allow you to disapply the presumption, yes?
Yes.
Now, it used to say those policies provide a clear reason for refusal. The government has upped the ante and said it's now a strong reason for refusal, which means it's going to be more difficult to disapply the presumption, even where you've got a footnote 7 policy. That's what they're intending to do, and that's what they've done. No longer a clear reason, it needs to be a strong reason. Yes?
And I'm not arguing with you in terms of the change of wording,
Right.
but I think there's a danger here in diluting, if you like, the importance of footnote 7.
Well, not really, because this is about when footnote 7 disapplies the presumption. And the government has changed the wording for when it disapplies from clear to strong. And we agree that's the position, yes? That's what's happened factually, yes?
The wording change has happened factually. I'm not going to disagree with you there.
No,
Yes.
and the reason they've done that is they want to strengthen the presumptions wording, not the exclusion of the presumption, but the presumption's wording,
They
yes?
do, they do want to, and
Yeah.
it's all part of the agenda to
Yeah,
deliver on
okay.
the 1.5 million houses. Yes.
Yeah, of course, of course.
Yes.
And then if we go to your proof 5.2, you set out the ultimate conclusion, I think, towards the bottom of 5.2 of Inspector Bristow, where he says, it's about 3 lines from the end, no 5-year supply inherent in my reasoning above, but there is nonetheless, there is a clear reason for refusing planning permission. So he's applying, as you would expect him to, the old test. We've now got the new test, yes?
Yes.
Right, good. Thank you. Now, other changes, please, to the MPPF. I think there are 3 others that we just need to pick up on. So have you got the MPPF there at CD 8.1, or you can look at your own version at CD 8.1. I think there's 3 other changes that are relevant to the discussion that we're having about what may or may not have changed. The first one is if you can go to paragraph 11 again of the MPPF.
Yes.
And obviously we've been looking, haven't we? If you go to 11D1, you can see that's where the word strong has replaced the word clear. Yes?
Yes.
And then if you look at D2, which is the other part of the presumption, any adverse impacts doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework. And then these words have been added, having particular regard to key policies for directing development to sustainable locations, making effective use of land, securing well-designed places, and providing affordable homes individually or in combination. So those words are all new, aren't they, within the presumption, correct?
Yes.
And if you look at the things the government is emphasising there, directing development to sustainable locations, and we'll come to this in a bit more detail in a moment, but we're agreed, aren't we, that the appeal site provides a sustainable location for housing development, yes?
No, we're fundamentally not in agreement.
Sorry,
on that
sustainable
point.
travel, we are agreed. In a sustainable location in terms of travel, we are agreed on that, aren't we?
I believe that was agreed in the statement.
Yeah,
of common ground.
that's agreed.
Yes.
Making effective use of land, well, that is definitely complied with here, isn't it? Yes?
Yes.
Yes. And then securing well-designed places, we're agreed on that, yes?
We're agreed in terms of the quality of the design, the
Right.
individual building,
Fine.
the lodge house.
Okay,
Yes,
fine,
but that-
fine.
that's
And then
the line.
providing affordable homes, well, that is something this scheme does, yes?
Yes.
Okay. Right, so that's the first of the 3 other changes. The second one is, can you go to paragraph 61, please?
Yes, thank you.
Now, this is another paragraph that changed to some degree. So you'll see it at the bottom, the very end, it says, currently, the overall aim should be to meet an area's identified housing need, including with an appropriate mix of housing types for the local community. This is the paragraph, isn't it, on boosting the supply of housing. And it used to say, didn't it, in the 2023 version that the inspector had before him, it used to say the overall aim should be to meet, and then it had the words, as much of an area's identified housing need as possible, including with an appropriate mix of housing type. And those words, as much of as possible, were removed, weren't they?
Yes.
And that's, again, part of the drive for 1.5 million homes, correct?
Yes, it is, but
Yeah.
we need to obviously read this in the context of you do have an objectively assessed need.
Yeah.
That's a policy off approach, isn't it? But that's not always reflected in the housing requirement, because obviously there are
No.
situations such as in Waverley, you
Yeah.
have so many environmental constraints that requirement is reduced.
Yeah. And if we then go to the final one, I think that we need to look at paragraph 78, this has changed very significantly, almost completely. Much of it has been changed. But this says, third line down, local planning authority should identify and update a supply of specific deliverable sites to meet a minimum of 5 years worth of housing against their housing requirement, etc. And then there's a reference to 5%, the 20%. And then can you just look at C, from the 1st of July 2026, for the purposes of decision making, only 20%, where a local authority has a housing requirement adopted in the last 5 years, examined against the previous version of the framework, and whose annual average housing requirement is 80% or less than the most up-to-date housing need figure, calculated using the standard methods set out in the National Planning Practice Guidance. So there's going to be an extra bite, isn't there, in July 2026 for authorities in that position, correct?
Yes, there is, yes.
Yeah. Is that going to affect Waverley?
Well, this is in relation to, this is a situation where you have an authority with a plan that's been adopted under the previous MPPF.
Yeah,
So they get to the 1st of July 2026, and then there's a 20% buffer applied.
right, okay.
So in the context of Waverley, with their current plan, they're in that's the world they're in at the moment.
Right.
So they've got a race ahead, haven't they? If they want to beat that. Now we know from the
They're not going to beat that date.
we
though,
know
are
that from
they?
the LDS they're not going to beat that.
No.
date.
Okay, so
No.
that is relevant to our consideration. It's relevant anyway to our considerations, yes.
It is relevant, but what
Yeah.
what is also relevant, just to carry
Mm.
on that a little bit further, is obviously the ministerial statement we've spoken about, and
Mm.
the Secretary of State was very clear there that local plans might not, they may not happen quick enough, and if they don't happen quick enough,
Yeah,
then development is steered towards those appropriate locations. And she mentions grey belt, doesn't mention national landscape.
yeah, I am coming to that. Now, I know you're keen to get to it and we will come to it, I promise you. Now, just to finish off on this, so we've seen the national policy, climate, the MPPF changes. We've looked at the changes that there have been since the previous appeal decision. Now, in your evidence in chief yesterday, you said that you considered that the national planning context had hardened against this scheme. Remember you said that?
Yes, I did say that.
Yeah. Now, I mean, in terms of this scheme being a scheme that provides much needed housing in an area where there are very acute housing needs and affordability issues, in that sense, the scheme is very much something that finds support from those changes in policy that we've just looked at, yes?
In terms of the narrow reference to government policy in
Yeah.
terms of delivering housing,
Yeah.
yes, there
Yes.
is a heightened need,
But
but
then
there is
you-
also
The
a strengthening
landscape
of government
point.
policy.
You want to talk about the national landscape point, yeah?
I was going to the LURA and the
Yeah,
CRO Act as well.
yeah.
That's the
Yeah, I'm
strengthening
coming-
element, and the
coming to-
PPG that's
Yeah.
associated with.
But that's not a change, is it, from, you talked about this position having hardened since the last appeal. But that statutory provision was in force at the last appeal, wasn't it? As we discussed
It-
earlier.
Yes, it was.
Yes, it
I
was.
think since that point in time, we have had an update to the PPG,
Yeah.
which I think is relevant. I'm not entirely sure when the guidance was published.
That was
fairly recent
after.
guidance.
That was December last year, so it was after the inspector's decision.
Okay.
Okay, now, can we look at Mr. Collins' proof, please, at paragraph 4.44? Because we've seen what the changes to the national policy agenda are, we've seen what the changes to the MPPF are. We've obviously seen the change, there was a change to the standard method. What I wanted to look is, if you go to Mr. Collins' main proof at 4.44.
Yeah.
He sets out, doesn't he, the leader of the council. So this was between the draft standard method and the draft MPPF and the July ministerial statements, and then the final MPPF standard method, etc., in December. The leader of the council wrote to the Secretary of State, I understand this is still the council's official position in relation to the implications of the revised standard methodology. I don't know whether you in a minute can comment on that, but just carry on. The letter states the standard method therefore does not provide a credible basis for preparing our new local plan, and it states the level of growth required to meet the standard method assessment of need is simply unachievable in borough, I think like Waverley, I think was what they say. At this time, without a LAR or draft options emerging plan, it's simply impossible to know this, Mr. Collins says. Well, I'll come back to that in a moment. But in terms of the council's reaction to the draft standard method was to write to the Secretary of State saying, this is simply not a credible basis for you to tell us the plan for, correct?
Yes, correct.
And that's where they put forward that, the report that you mentioned to me a moment ago, is that right?
Yes.
Yes. So that's the council's position. Is that still the council's position? As Mr. Collins says he thinks it is? Is it still their position? It's not
I'm unclear of the.
You don't know what
the
their
current
position is?
position.
Okay, fine. And as we discussed earlier, the reaction of the government to that was it actually further increased the numbers, didn't it? Because in the draft standard method, the number for Waverley per annum was 1374,
Mhm.
and it went up to 1481. So the Secretary of State's response to it's not credible for you to ask us to deliver that much housing was to increase it by a further 8%. Yes,
That is correct.
That is
but
correct.
Just to give a little bit of background to that, I think this where we're going with it. If I can refer the respect to my paragraph 6.10
6.10.
in my proof.
Yeah.
And I accept the fact that the standard methodology does put the numbers up substantially. There's a huge need for housing in Waverley. Nobody's disputing that.
Yeah.
But it is very much central to the government's policy. And we know that from the update to paragraph 1 of the NPPF, that we have a plan-led system. And it may not always be possible to fully meet the, as I state in 6.10, fully meet the objectively assessed needs. Now, that's something the previous inspector referred to, but more importantly, it's something that's also referred to in the PPG. And I provide footnote 12, which is paragraph 041 of the PPG. So that's just a bit of, sorry, just put a bit of context to that, Mr. Ritchie.
But I mean, just a couple of things on that. I mean, I will come back to this one, but that paragraph of the PPG that you're citing there, that's about plan making, isn't it?
Yes, it is, yes.
Okay. So it's about plan making. And if this council had an up-to-date plan and they had a constrained housing requirement figure that had been accepted at examination, that's what we'd be looking at, wouldn't it, to assess the housing need? Yes.
Yeah, I believe the figure in the plan was a constrained figure.
It was,
but there was exceptional circumstances
Yes.
generated last time around.
Exactly. But if they had it, but the problem is we don't look at those figures anymore, do we? Because the plan's more than 5 years old and we now look at standard method, don't we?
Yes.
Right. So in a world where this council had a new plan and they'd persuaded an inspector that they should not seek to meet their full need, but that they should be constrained, we wouldn't be looking at the standard method, would we? We'd be looking at the constrained figure in the new plan. Yes.
Yes.
Right. So that's factually the position. Now, the next thing is that this paragraph that you refer to then talks about, doesn't it? It says its policies for protecting these areas may mean it's not possible to meet objectively assessed needs for development in full through plan making process, and they are unlikely to be suitable areas for accommodating unmet needs from adjoining non-designated areas. I mean, the need that we're going to be talking about in a bit isn't anything to do with unmet need from elsewhere, is it? What we've looked at is the need of this area, correct?
That says, well, the standard method deals with just the.
Yeah, and that's what we're looking
And
at.
it's like a policy off
Yeah.
approach.
Okay, yeah. So we're not looking at any uplift from other areas.
No.
Okay. Now, the other thing is that just can I ask you to go again in the appendices, please, to Mr. Collins' proof. Can I ask you to go to Appendix 3, which is Mr. Neam's report, and if you so it's NID 5 that you need to go,
Yes.
5.1.
Thank
I'm
you.
just going to find you the electronic page, if you give me a moment.
Thank you.
Yes, so it's electronic page 230.
Thank you.
Well, actually, we should probably start at 229. Start at 229, just so we get some context. Oh, old school, it's Mr. Neam's report at page 19 over onto 20. Yeah. And there should be a heading at the bottom of the page, scenario 1.
Yes, I have
Yes.
that. Thank you.
So scenario 1, based on LLP, LPP2 and made neighbourhood plan supply sources. So this scenario is based on identified deliverable developable supply, namely housing land supply provision, LL2 examination based neighbourhood plan base. And then various things are discussed about this option. So, but you go to 7.7 on the next page. It says the trajectory clearly demonstrates that even with the supply identified by the council, there remains a shortfall of 2,874 dwellings at the end of the plan period. And then this, for the inspector's information, if only the LPP1 minimum housing requirement is applied to this trajectory, there remains a shortfall of 1,695 dwellings. So even if we were to throw aside all of Mr. Neam's various trajectories about what the housing need would be at the end of the plan period, and we were actually only to consider the housing requirement, which is a constrained housing requirement, isn't it, in the current plan? Yeah.
Yeah.
This council would still be 1,695 dwellings down at the end of the plan period, even applying the constrained figure from the existing plan. Yes.
Yes, that's
Yeah.
yes, that's correct.
Okay. So, I mean,
That's that's my reading of that
yeah,
paragraph.
yeah. And I mean, I was going to ask you two things about that. I mean, first of all, I think you said yesterday you didn't think that Mr. Neam's trajectories were of much assistance to the inspector, but you don't question, do you, any of the arithmetic that's led to, or the methodology that's led to these various numbers, do you?
No, I'm not.
No.
But just to add to that, I'm not questioning the maths, if you will. But I think, and you may come on to this, what we're talking about here, what this is leading towards is a 5-year housing land supply discussion.
Yeah.
And this site, in my view, is not going to come forward. It's
Well,
not going to deliver within 5 years.
not-
So perhaps that's a discussion we're about to have. But
No, well, it's not actually leading there, is it? Because what we're looking at here is what the shortfall will be at the end of the plan period. So that's 2032. So that's not 5 years, is it? That's 7 years. So this is looking not beyond 5-year supply at the overall plan period. Yes?
yes,
Okay.
Yeah.
Now, so we've got your position on Mr. Neam's. You don't think it's that helpful, but you're not actually questioning the numbers or the methodology. On Mr. Neam's analysis, even if we applied the LPP1 housing requirement, which is a constrained figure, yes, we still end up 1,695 dwellings short at the end of the plan period. Yes? Agreed?
yes.
Okay. Now that's all fine, but when that constrained figure was accepted by the previous examining inspector, the overall need in Waverley would not be as high as it now is because of the new standard method, correct?
Correct.
So it's constrained, but based on a housing need figure that is itself now much higher.
Yes.
Yeah, okay. And so when you refer in your 6.10 of your proof to the National Planning Policy Framework making clear the scale and extent of development in these areas, which is national landscapes, national parks, should be limited in view of significance of enhancing the landscape's scenic beauty, it may mean that it's not possible to meet objectively assessed needs for development. The position here is, even if you apply an outdated, constrained figure from the local plan, at the end of the plan period, this council will be 1,695 dwellings down, correct?
That's my reading of that paragraph, but I'm not contesting the maths behind it.
Okay, fine. Good. Now let's come back to where we were on all of this, because I slightly jumped forward there. Now I think you wanted to talk, and this is fair enough. You made this point to me about 5 times, so I think I better get you the chance to talk about it now. Paragraph 8.3 of your proof, please. Again, you refer, don't you, here to, because I've been talking to you about how the impetus for new housing has become a sort of new feature of government policy. You want to talk about the strengthened duty in Lura, and you do refer to that in your paragraph 8.3. Now, just on the factual position, we have been through this a number of times, but I want to be absolutely clear before we go any further. We're agreed, aren't we, that the statutory duty was in place when Inspector Bristow made his previous decision, yes?
Yes.
Yeah. And just in your 8.4, you say, at the time of the first appeal, Lura had received royal assent in October. That's correct. And then you say it passed into law on the 26th December 2024. That's incorrect. It was 26th December 2023, wasn't it? When it came into force. Otherwise, it wouldn't have been in force when Inspector.
Excuse me. Yes.
Yeah.
that's
So it's
correct.
2023. So we just correct. We
Apologies.
correct that. No, that's fine.
Typo.
I just wanted to be sure on the chronology before we set off.
Yes.
And then in 8.3, if we go back to that, you say there is now a strengthened duty on relevant authorities to further the purposes of national landscape, as referred to above, and statutory guidance through the PPG. So just pausing there, I mean, statutory guidance is a specific thing. It's guidance that is made under a statute. So is there guidance made under a statute that you are talking about here? Because I don't think there is any guidance making power in Lura for protected landscapes. There is a regulation making power, but the Secretary of State's not made any regulations. So do we cross out statutory guidance and just leave it as guidance?
I think the point I was trying to make here in
Yeah.
terms of referring to statute
Yeah.
was perhaps the wrong vocabulary. But the point I'm trying to make is that the status you give to the PPG has now been established through the
All
Mead
right.
realisations case law we all know about now, so it has equal standard to the standing to the framework.
All right, but if you, but so you're talking about the PPG here, are you?
Yes.
Okay.
Yeah.
So yes, because I think that's fair. You say to you statutory guidance through the PPG, but you mean guidance through the PPG, and then you're referring to Mead. So that's fine. But can we just look at what the guidance actually says in the PPG in relation to the statutory duty? So we've put the PPG in NID, I think it's 13.17. Yes, NID 13.17.
Yeah, thank you. Yes, thank you.
So if you go to the second page, this is where we've got the extract from where the PPG deals with the statutory duties that apply to national landscapes and other landscape designations. What it says in that first paragraph is that the provisions require you in exercising, performing any functions in relation to also to affect land in national parks, national landscapes, you must seek to further the purposes for which these areas are designated. So that's not actually giving any real guidance, is it? That's just telling you what the statute says, that bit, correct?
That is correct.
Yeah.
Yes.
And then it says guidance on the operation can be found in the DEFRA guidance on the duty. And then there are some other sentences below, but in truth, there's no substantive guidance here about the duty. One's being referred, aren't you, to the DEFRA guidance for to how the duty operates, correct?
Yes, it is correct. Yeah.
Right. Okay, good. Now we'll come to that in a moment. So that DEFRA guidance, as we established, I think, a moment ago, that's new in the sense it wasn't before Inspector Bristow, correct?
Correct.
Yeah. Okay. Good. Now I'll come to that in a moment. In fact, we might as well just quickly look at it now, and I've got some other questions on it. So NID 7.11, please. NID 7.11. Yeah, NID.
Excuse me.
Yeah, NID 7.11 should be the DEFRA guidance.
Yes.
Yeah, so that was published in December of last year. So that's obviously well after Inspector Bristow's decision. Now, in this document, you, I think, mention this in your proof, don't you? But you don't carry out any analysis, do you, of its contents in any detail, or what it says or doesn't say? Is that right?
No, that's right.
Yeah. So I just wanted to ask you about that guidance a little bit more. So if you go, please, in the guidance to just have a look. If you go to page 4 of 8.
Yes.
You'll see at the bottom of the page, it says when seeking, under the bullet points, when seeking to further the purposes, relevant authorities should consider the information contained in a protected landscapes management plan. Management plans describe the natural beauty, special qualities and key characteristics of and targets and objectives for the designation. Now, I think you referred to this in your evidence in chief because it's right, isn't it, that one of the things that this document multiple times refers you to in assessing whether you're going to further the purposes is the management plan, correct?
Yes, correct.
Yeah. So it does emphasise, doesn't it, very strongly the importance of compliance or otherwise with the management plan, yes?
Yes, and that is also, as we know, is bound into policy, it's RE3 as well,
Yeah.
the reference in there as well.
Yeah. So the management plans are also important because RE3 refers to them. Yeah.
Yes.
Okay. And we'll come to the management plan and RE3 in due course. So good. That's one useful point. Now, if you also look at this document, if you go, please, to page 6 of 8.
Yes.
there's a heading, what a relevant authority should consider. Second paragraph, do measures which would further the purposes, align and help to deliver the targets and objectives in the protected landscapes management plan. So you need to consider whether the measures would further the purposes of delivering the objectives of the landscape management plan. And would you agree with me, in a case like this, we have to consider, don't we, in our appeal, not just the housing, we also have to consider the 78% of the site that's not being built on, but which is being enhanced. They would both have to be considered, wouldn't they?
Yes, they would.
Yeah.
Yeah.
And then if you go down the page, the third paragraph from the end, has the relevant protected landscape team been approached for their views on whether or not measures help to deliver the protected landscapes management plan and further the purposes of the designation? So as I understand it, again, I think you referred to this in chief. Does this come down to the views of the, in your view, the views of the AONB unit, as I think they were called? I think they're called National Landscape Unit now.
Yeah, yes, it's, so yes, you have Catherine Atkinson, Chair of the Surrey Hills National Landscape Board.
Okay.
And also obviously there's Mr Smith, Clive Smith, who are the, as I understand it, the authors of that management plan.
Yeah.
Or the board are.
Okay.
Yeah.
Well, I'll come to their views shortly, but if you then go to page 5, the other thing that you're referred to at the top of the page, so page 5 of 8,
Yes.
it says, so I think this is relevant to what we just said. It says dialogue with the protected landscape team, and then we see who they are, can assist the relevant authority. I'll come to their views in a moment. Then it says relevant authority should also refer to the protected landscapes target and outcomes framework. Yeah, so that's a separate document that was issued in January 2024. Now, you don't deal with that document, do you, in your evidence as to whether it's complied with or not?
No, I don't know.
No. And that document came out after the previous inquiry finished, but before Inspector Bristow's decision. And as far as I'm aware, no one drew it to his attention. It's not mentioned in his decision, is it?
No, it's not.
Okay, good. All right, so I said I'll come back to the views of the unit in a moment. I just want to finish looking at these issues around compliance. So the position is that although the previous inspector obviously was aware of the statutory duty, he was aware of the statutory duty, and he considers it, doesn't he, in his decision, he didn't have, did he, the benefit of the DEFRA guidance, because that came afterwards, yeah?
Yes.
The PPG that you've referred to, not that that really says that much, that really just refers you to the DEFRA guidance, yeah?
Yes.
Nor the framework that we've just talked about, which is referred to in the guidance. He doesn't seem to have had that because no one raised it with him when the inquiry had finished.
He obviously refers to the LURA.
Just to the LURA, yes. So he
Yes.
didn't, but he didn't have the guidance, the DEFRA guidance, the PPG, and he didn't seem to have the framework that's referred to in the guidance either. No, okay. Now, in relation to the Act itself, I don't know how much you've looked at this, but as I said, I mean, the Act has a power in it to make regulations so the Secretary of State can tell an authority how to comply with the duty, but there are no regulations, are there, under the Act? You don't know?
No.
You don't know?
I don't know.
Fair enough. And again, the Act, one of the other things the Act does is, again, a bit like RE3 emphasises the importance of management plans and the DEFRA guidance does, it actually has a number of other provisions about management plans. So again, the Act itself is emphasising, would you agree with me, the importance of the management plan? Yes?
I can't comment.
You don't
on
know.
that. I don't
Okay,
know.
fine.
No,
That's fine.
My
That's
reading's
fine. That's fine.
Section 245. Yeah.
Okay, no, that's fine.
you.
Good. Now, can we just look at your proof 8.5, 8.6, first of all? Now, again, you may not be able to help me on this, and in which case I'm very happy to move on, but you are referring here to a consent order in another case that was entered into by the Secretary of State. And
Yes.
you are referring to it as being, you say in 8.6, a firm commitment to the protected landscapes, despite the delivery of need to deliver the houses. Now, I don't know how much you know about this case, but because you've raised it, I just want to sort of broach a few things with you. That case wasn't about a grant of planning permission at all, was it?
No, it wasn't. No.
So it was actually a case about a screening direction
Yes.
on permitted development by railway undertakers.
Yes.
And the basis upon which it was quashed was that the screening direction failed to make any mention at all, refer to, let alone consider the statutory duty.
Yes.
Yeah, so it's not that it tells us anything about the nature of the duty. What it does tell us is you can't completely ignore the statute when making planning decisions, yes?
Correct.
Yeah,
Yes.
that's as far as it takes us, isn't it?
Yes, and the,
Yeah.
the reason I made reference to it was because the inspector mentioned in his decision that there was no case law. He
Yeah.
was aware that the
Okay, fair enough. But we
At
do
the
now
point of
have,
time-
don't we? We do now have a case law because we've got the New Forest
New
case.
Forest.
Yeah,
Yes, we do.
okay.
Yes.
I'm not going to ask you about that because that's obviously up for submissions. Okay, fine. Now, I want to come back to just other things that have changed between the two appeal decisions. Can I ask you to go to Mr. Collins' main proof, please?
yes.
So his main proof, and it's his paragraph 10.3 on page 94.
Yes, have that.
So
Thank you.
10.3, he lists 9 matters here which have changed either in the national context or the local context or scheme specific. So just to run through them to see if there will be, we've discussed the first 2 already, haven't we? In fact, the first 3 we've discussed already, haven't we, Mr.
Yes.
Johnson? Yeah. So the 4th one, which we'll come to later, is the Turndon. It says appeal, of course it's not an appeal because it was a call-in, but the Turndon application. So that was redetermined by the Secretary of State after the previous inspector's decision, correct?
Yes.
Yeah, so we'll
correct.
come to the detail of that later on. 5 we've discussed, there's the removal of the 2 trees. So part of the tree loss that the last inspector had regard to has already been lost, correct?
Yes, correct.
6, there's been further vegetation growth, which has led to the new AVRs, correct? That's a factual matter, that's a new part of the material, yes?
Yes.
Then more detailed design review, evidence of Mr. Pullen, and also a more detailed design condition. So 2 things this inspector's got that the previous inspector didn't have is Mr. Pullen's done a detailed design review. That there was no design review before the previous inspector, correct?
Correct.
And secondly, there was a design code condition, but there's a much more detailed one that's now proposed, and I think it's agreed, isn't it, the design code condition?
There is a design code.
Yeah, and that's agreed, yes.
Yes, it is. Yes.
But it's a much more extensive condition than the one that was agreed at the last inquiry. It's much more detailed.
It is. Yes.
Yeah, it is. We've then got 8, which we've just discussed, the publication of the guidance on the new statutory duty in respect of the national landscape, yes?
Yes.
And also, we better add to that, we've now got case law like the National Forest case, haven't we? Yes?
Yes, we have.
Yeah,
Yes.
okay. And then 9, scope for additional affordable housing contribution. So we'll come to the detail of this, but we're offering, aren't we, on site, 35% affordable housing, which is 5% above the policy requirement, correct?
Yes.
But we're also offering on top of that an off-site contribution to go towards affordable housing in Hindhead or Hazelmere, correct?
Yes, that is correct. I'm not sure if this is the right point to discuss that.
No,
I had discussed that with the head of planning, and she's taken advice from the housing team as
Yeah.
well on that sum of money. And what actually does that actually really achieve?
Mhm.
And the response is, I don't know, I'm not a viability expert myself, but it actually achieves very little in terms of affordable housing. Doesn't deliver a whole
So-
unit, if you like. I think it's
So what the council
200
doesn't want that money, is that right?
£200,000.
The council doesn't want the money, is that right?
It's just something I'd bear in mind in my weighting, given in terms of the weight you'd give that.
Well, I'm sorry, do the council want this money or not? Are they going to be able to make use of the money to help?
I'm not
deliver
saying the council don't want the money. I'm
Right.
just referring to the weighting I'd give to that sum of
Okay.
money.
All right, well, we'll pick up the rest of that on the 106 session because I will see what the seal compliance statement says in relation to that when we see it.
Yes. And may I just add,
Hmm.
sorry, in terms of the list of the points 1 to 9, which
Yeah.
Mr. Collins has raised, I've similarly have a list myself just to assist.
Of points that have changed.
Points that have changed. Now, I think we're pretty much
Okay,
agreed,
yeah.
but there's one additional one which I'll
Go on
put
then,
in there,
yes, what's your?
which is just literally the mead realisations case that gives that PPG the same status now. Yes, rolling about. I do apologise to
Well,
broken record, but it's an important point to make because the PPG now has a heightened status than it did at the time previous because we now have mead realisations.
yeah, I know you keep
And
going back to it,
That is a fundamental change
But-
since the last decision.
but in terms of PPG provisions that you refer to, yeah, I mean, am I wrong? There's only 2, I think, aren't there, that you refer to? One is the PPG guidance on the protected landscape duty, which doesn't actually, as we've agreed, say very much. It just takes you to DEFRA guidance, yeah?
Yes.
And the second one is the paragraph that we discussed at some length a moment ago about the fact that in a national landscape, you might not be able to meet all of your need. It's the one that you discuss at 6.10 of your proof, yes?
Yes, that's correct.
Is there any
Yes.
other part of the PPG you're actually relying on in support of your case?
No.
No. Now, I will come back to that paragraph that you refer to in 6.10. I mean, I've already tackled with you, what the position would be even if we were assessing need against the constrained figure. I don't want to go back to that, but there's another point on that I want to come back to you on, but I won't deal with it now because I need to come back to it in a different context. But that's it for the PPG. Now, can I just say to you, there's a couple of other things I would like to talk about as having changed. One is, we've already discussed this, I think, but obviously Natural England have updated their position in relation to our SANG, haven't they? And accepted that what they'd said previously was potentially misleading. So that's a change, isn't it? We've got a different set of representations from Natural England.
Matt, would it be possible to go to that representation just so I
Yeah.
can be clear on my answer?
Sure. I mean, if you want to make the point that they're still objecting on AONB grounds, I agree, they are. But their position has changed in relation to SANG. So I don't know, do you want to we can happily go to it.
I think that was where I was going to go.
You wanted to go to, yeah.
The objection they've made.
So they still object on
Stands
landscape,
on
landscape
national
grounds,
landscape,
but
yes.
they have now recognised that the provision of SANG would be beneficial in a wider sense. That's what's changed, not their position on the national landscape. So if that's what you wanted to go to, we can
That's
probably
where I was
avoid.
going.
Okay.
So
Well, we can
for
we can-
brevity, we don't need to go
we
there.
may come back to it on another point, but that's fine for now. Okay,
Good.
good. Now, I just want to say there are two other things I want to talk about that have either potentially changed or not changed, depending on what view you take about all of this. So the first one is the emerging plan process. Okay. Now, prior to Inspector Bristow's decision, or when Inspector Bristow made his decision, he had before him, didn't he, the December 2023 version of the LDS, correct?
Yes.
And we don't necessarily need to go to that document. It is in the core docs, but that set out a programme which culminated, didn't it, in adoption in November 2027. That was the previous LDS.
Mhm. Yes.
Yeah. So, but the new LDS, the March 2025 one, which I think is NID 7.15, that is now pushed that date back to July 2028, correct?
Yes, that is correct. Yes.
Yeah. So that's changed in that Inspector Bristow was under the impression that this council would be likely to have a plan in place in November 27, but on the council's own case, it would now be July 28. Yes.
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 Correct,
Now,
yeah.
in addition on that, I don't know if you can help me in relation to this, but in the older version of the LDS, the council allowed 14 months for examination, so 14 months between submission and examination. And in the new LDS, they're submitting in December 27 with adoption in July 28. So they've abridged by 6 months. So from 14 months to 8 months, the time for the examination period. Yeah.
Yes.
Yeah. Now, if this council is going to, which seems likely, not seek to meet its full need, that is going to potentially be a controversial examination, as many of these examinations are, correct?
Yes.
Yeah. So if the time taken for the examination was actually as long as the council originally thought it was going to be, 14 months, we add 6 months to July 2028, we would get to January 2029, wouldn't we?
I don't think you can. I don't think you can draw any conclusions on that. All examinations are contentious, aren't they?
Yeah.
The majority of the
Yeah.
conversation revolves around housing numbers.
and-
We've all been there.
Yeah.
So
And how many local plans have been adopted in accordance with their timetable rather than many months afterwards? Any that you're aware of that have actually met their LDS timetable? Do you know any?
I can't qualify that either
No.
way. I
No.
can't think of
All
an
right.
example either way, I'm afraid.
Well, the inspector will have his own impressions about what happens on that. Now, okay,
Yes.
now, I then want to just ask you about this. 7.15 of your, so related to where we are on the plan, 7.15 of your proof, you say, as I address below, I agree with the broad approach taken by the first appeal inspector to paragraph 190. We're coming to the detail of that, but including the recognition of scope for other sites to come forward through the local plan review call for sites process, yes?
Yes.
Now, just on that, factually, the call for sites was launched 18 months ago, wasn't it?
Yes.
Yeah, and it closed, formally closed 13 months ago. There was a call for sites and it was open for a certain period of time and it closed, think about, it was March, I think, March last year. Yes?
What I would say, just for clarity,
Yeah.
and working with many local authorities for many, many years, the
Yeah.
call for sites process
Yeah.
is generally tends to be an open-ended process. So if you have developers who, say, a couple of months ago thought, oh, here's a site, I'd like to have it included, it wouldn't stop them submitting that site. And I'd have thought most national house builders will be submitting sites throughout that whole period, right up until today and go forward.
But formally, it opened 18 months ago and it closed 13 months ago. Yes?
It did formally, yes.
Yeah. Now,
Yes.
I mean, since that time, of course, national policy has changed, including, of course, the provision on grey belt, which I know you want to talk about, and we'll come to them. But the council hasn't formally relaunched the call for sites, notwithstanding the fact that we now have this concept of grey belt, has it?
No, it hasn't. But
No.
but I imagine there's probably that as most of my clients would probably react to an LDS that refers to engagement and visioning and issues and options running through the summer and into the autumn this year.
Okay.
That would be a trigger for
Yeah.
most national house builders to start submitting sites.
And the position is that despite having formally closed the call for sites 13 months ago and opened it 18 months ago, the council hasn't published its law, has it? Hasn't published an updated law.
No, and I think part of the issue here is that we have a new NPPF and the grey belt issue is something that the authority are
Yeah,
having
is
to
it
review.
possible then the council will think that it needs to formally reopen the call for sites in order to ensure that it gets brought forward all the relevant grey belt sites that are out there, rather than relying on developers to come forward of their own motion? Is that possible?
It's possible, yes.
It is possible. Okay, so although Inspector Bristow made the comment that you rely on about the fact that the call for sites process might bring forward other sites, I mean, in terms of what's in the public domain, we are no further forward now than we were at the previous inquiry, are we?
Not in terms of what's in the
No.
public domain, no.
And in terms of the council, I mean, you have agreed with us, and we'll come to this, a list of alternative sites for assessment on this appeal, yes?
Yes, I have.
Yeah.
If you
Okay.
take that narrow approach in terms of
Yeah,
paragraph
well-
90, but yes, we've agreed that list.
We've agreed
Short
that
list,
list.
yes,
We've
yeah.
agreed that list. And those are the sites that we must consider in looking at alternatives, yes? Because that's what we've agreed.
As part of that broader consideration, yes.
What you mean, part of the broader consideration of exceptional circumstances?
Yeah.
Yeah, fair enough, fair enough. Okay, now, in addition, final thing on, I think, on the local plan, could we look at Mr. Collins' rebuttal, please? Mr. Collins' rebuttal, 2.11 and 2.12.
Can I ask for, sorry, an NID reference to the rebuttals?
Yeah, good question.
Thank you.
Oh, no, because that's proofs, isn't it? So it's NIDs
11, isn't it? NID 11. Just
11.1,
spotted it.
yeah,
Thank
NID
you.
11.1.
Thank you.
NID 11.1, and if you go to page 9
Yeah.
in that document, there's a heading devolution, which I will, I just want to explore with you in relation to the local plan. Can I just ask you, the call for sites that took place, that included a call for sites for Sang, didn't it?
I believe so.
It did, yeah. So, I mean, that's a recognition, isn't it, by this council that they do need sites for Sang, correct?
Well, the issue over Sang, that was raised at the last local plan examination. And the inspector there in the inspector's report, just to refer you to CD 7.57, 7.57 CD 7.57. That's the inspector's report. And in there, there's a reference to, obviously, is there enough Sang to meet the wider housing need, to support the housing coming forwards? And the inspector does refer in there to the town of Hazelmere. It's close to Wilden Heath SPA, but due to the amount of natural green space in the area, Sang is not the only potential mitigation measure, and there is no need for a strategic Sang.
Well, just pausing there, I presume the council doesn't waste people's time by calling for sites that they don't actually want or need. The council, in its call for sites, did call for sites for SANG, not just for housing, correct?
They will do, they
Yeah.
will do that because
No.
of course they don't know what
Yeah.
the, perhaps at the point they didn't know what the housing need
No,
was at that point. So of course it's a worthwhile exercise and see
All right.
what's
Okay, now
available.
we'll come to this. I mean, I think the point's been made that there are only two allocations that are above the,
Yes,
is it 50 units?
that's the
Yeah.
top threshold, yes.
Yeah, so, okay, and one of them's the Royal School, which I'll come to later on, but
Yes.
just to understand this, I don't want to talk about the under 20 at the moment. I will come to that when we talk about Old Grove, but between 20 and 49, the LPP2 suggests that you do need mitigation, but it may not necessarily have to be SANG. It could be, I think they call them HIPs, don't they, here, I think. Is that right?
Yes, that is right. And
Okay.
the actual wording is in paragraph 7.14 is
Yeah,
may require some form of mitigation.
yeah.
And then yes, such as HIPs,
So,
yes.
so for example, it could be SANG. It could be a strategic SANG. You need some mitigation above 50. Sorry, no, you need some mitigation above 20 up to 49. It could be by SANG, which is probably why the council are calling for sites, because it's a way to mitigate those sites, isn't it? It may not be the only way, but it is a way. Yes?
All it's a bullet point, isn't it? The bullet point refers to is may require some form of mitigation. Doesn't specifically mention SANG. SANG is mentioned in the third bullet,
Yeah.
50 dwellings and more. But
Yes,
not
50 it
in
must be SANG, I think. Is that right? Or is
may-
that optional too?
Yeah, it's a little bit opposite, and more may require a SANG and
All right.
associated appropriate
But-
assessment.
But just, I mean, whether it's the over 50 units or the 20 to 50, it does, the position on the plan is if you're over 20, you do require mitigation. We agree it doesn't necessarily have to be SANG, particularly up
Yes.
to 49, but it could be SANG.
It could,
Yeah, it could be
Yes.
SANG. Okay, thank you. Now, in relation to Mr. Collins' rebuttal that I asked you to go to, we know from the council's LDS that we are looking at, aren't we, on the council's view, adoption in July 2028. And I've put to you that it might well be January 29 or later, but take the council's position for now, July 2028. There's proposals, isn't there, for devolution. And Mr. Collins has set out what's in the public domain about the merging of authorities down here. And he says at 2.12, devolution adds another complexity to the progression of the plan, noting that the LDS proposes adoption in 2028 after the likely transition to a new local authority in April 2027. So in addition to all of the other things we've got going on around the timetable and things that have changed, the council won't have adopted its plan before it's transitioned to a new authority, correct?
if there is to be a unitary
Yeah,
authority.
if these proposals go ahead as they've been published so far, then that's what will
Yes.
happen. Okay. And you would agree with Mr. Collins that at the very least that does add an extra level of complexity, doesn't it?
I don't think that necessarily results in a you can associate that with the timeframe for the emerging plan, because I work with authorities across from Dorset, obviously Surrey, Hampshire and West Sussex, and unification is something that's happening across the board. It's already happened, because for Wiltshire, unitary, and we know also Bournemouth, Christchurch, Paul, BCP, unitary authorities. Now, what's happened and I'll use BCP, Bournemouth, Christchurch and Paul, that did go down the unitary route, the way they progressed with their local plan reviews is they carried on with the individual local plans, and they took those through to adoption. And then obviously at that point, a review happens and a new plan's put together for the whole of the administrative area. So it doesn't necessarily mean that, there's a unification on the horizon, therefore that's going to slow down our local plan review process.
Well,
It doesn't tend to work that way, because authorities are obviously being encouraged to get their plans in place.
yeah,
And that's likely to happen, I'd suggest, if that was to happen in Waverley, that's likely to be what would happen here.
but in reality, on the council's own timetable, which we would say is unrealistic, but on its own timetable, Waverley will never adopt another local plan. If this plan that's currently in vision is adopted, it will be adopted by the new authority. Yes? Because
Well-
there'll be on the currently published plans, there'll be transition to the new authority in April 27. So that's well before the plan's going to be ready for adoption. So Waverley will never have another plan for itself, but the new authority could adopt that plan. Yeah. Or it could say, no, let's start again and do a plan for the whole area. Yeah.
They could do the latter,
Yeah.
but obviously the government's
Yeah.
strong emphasis on getting plans in place.
Okay.
I'd imagine,
All right.
and also obviously the new local plan, it gives them protection, doesn't it? So I'd
Okay.
imagine that they'd carry on.
Okay, right. Before lunch, there's a couple of other things I want to just pick up with you on, and these are things that I would say to you have not changed, okay, from the previous inquiry. The first one I want to pick up with you is the position in relation to Scouts. And so can I ask you to go to ID 4.3, please? ID 4, so not NID, but ID 4.3.
Yes.
And actually, on our way through, if you could go to page 25 to start with, actually. So I'm going to come to what's said in the council's closing at the last inquiry on Scouts, but just en route to that, if you've got page 25,
Is this, sorry, PDF page 20?
PDF 25, yeah, I think
Yes.
it's number 25 as well.
Yeah.
Do you see paragraph 49C, which is the paragraph just above paragraph 50? Do you see that it's recorded?
Oh, excuse me, sorry, I may have the wrong,
Yeah, ID
ID.
4.3, not yeah,
oh,
ID,
NI, sorry.
not
I
NID,
apologise.
not NID, ID,
ID.
ID 4.3, and it's page
me.
25.
ID 4.3. I'm just struggling to find that. ID 4,
ID 4.3.
4.3. Yes, sorry. Got
Yeah.
there. Thank you.
If you could just go to, I'm going to come in a moment to page 26, which is where I mainly want to go, but just en route to it, page 25. Page 25. Do you see above
yes.
paragraph 50, there's paragraph C, and
Yes.
just 3 or 4 lines from the end of that, Ms. Dring records what we've just agreed, that the current call for sites, so that was the call for sites that was ongoing when the last appeal was heard,
Yes.
does specifically seek potential Sangland. So we see that confirmed
Yes.
there, don't we? Yeah. And we agreed that in any event. But if you then go down to the next page, can I just read to you what the council was saying about the position with the Scouts back on the 9th of February 2024. So that's 14 months ago now.
Yes.
And I just want to look at what the council was saying. So they say it's not accepted there's a need for the group to relocate. The Scouts are currently located at the Wayhill site. Uncertainty as to whether they could remain there due to the emerging DSO4 allocation. But that issue is now resolved following the adoption of Local Plan Part 2. The allocation excludes the land currently occupied by the Scouts. Waverley does not accept the Scouts' account of the lease negotiations to date. But the key point is that there is a second draft of a lease in circulation between the parties. And then during the virtual session, Councillor Aslam confirmed that she'd specifically asked for confirmation. Now, that's what she also said to this inquiry, albeit she hadn't checked again in the 14 months that followed. And then 52, copy of the lease was not available. Mr. Buckler said it contained a break clause allowing Waverley to relocate the group. Clearly, the draft release remains subject to negotiation. If such a clause were agreed, it might allow for additional development on the Wayhill site. Crucially, it would not leave the Scouts without a home. Mr. Buckler did not suggest the Scouts would reject the draft lease. It's acknowledged the facility being offered by the appellants may be more desirable in certain respects, but that does not mean it's needed, and the location may have drawbacks, less convenient for existing members to access, greater reliance on cars, etc. So, I mean, frankly, there was a little bit of a sense of deja vu on this side of the room, because in reality, the position that the council are taking at this inquiry is very similar to what they were saying 14 months ago, correct?
Yes, that is correct. Yeah.
Yeah. Now, just so I can understand your position in relation to this, you are, insofar as you're giving information about what's going on in relation to the lease, you're doing so on instructions. You have no personal knowledge of the position at all, do you?
I've had a conversation with property
Yeah,
services.
so no personal knowledge of the position at all. It's just from conversation with somebody at the council.
From officers
Yeah.
dealing with the
Right,
scouts.
so it's
yes.
on instructions. You have no personal knowledge of the negotiations.
No,
Have you seen any of the correspondence?
no, I
No.
have seen there is a draft lease,
Mhm. Well,
which I've seen.
there was a draft lease 14 months ago.
Yes.
Yeah, okay.
That's all I'm saying.
These negotiations, according to the scouts and the documentation they put in, have been ongoing since 2015, correct? Or do you not know?
I don't know.
Okay.
I did hear
And-
that discussed. Yes.
And the scouts have also referred to the fact that in the background to all of this, there are court proceedings ongoing, aren't there? Which have been stayed. Do you not know?
I don't know.
No. Okay.
Sorry.
You haven't put the lease before the inquiry. That's not happened. So we don't
No.
know what the terms are or what the negotiations are at the moment, do we?
No.
No. Okay. Now, just so I can understand this, I mean, clearly there's been a ongoing negotiation about a new lease. If the scouts relocate to our site, the proposal is that they would have the freehold of their premises. Yes? Correct? That's what the 106 provides for.
Yes.
Yeah. So they would have security in terms of their property for all time without having to be involved in what they've been involved in for the last many years of negotiating new leases, etc. Correct?
Correct.
So that would be an advantage to them, wouldn't it?
Yes.
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 And secondly, you accept, do you, as Ms. Dring put it in the closing, that there are obviously a number of desirable features of the new facility compared to the old, i.e. it's a brand new facility, etc. It's in a woodland location. Those are advantages to the new location.
I would agree that there are advantages.
Yeah.
I don't think there is a need.
Well,
But I would agree there
No.
are advantages.
Okay.
Yes, I think there's a suggestion of some additional
Okay.
land around the
yeah. Yeah.
house and so on. Yeah.
Okay. So I know you don't accept need, but I mean, the amount of weight you give to the benefit of the scouts, which I think is limited, is that right?
Yes, it is limited.
That's based on your view that there is no need for them to have a new premises.
Yes.
So suppose the inspector comes to the position that he can't really be sure where things are with the negotiations, and this uncertainty has been ongoing for many years. And he decides that actually there is a need for them to move, to have their security of tenure, etc. If that was his view, he would have to give more than your limited weight, wouldn't he, to it? If I know you don't agree, but if there was a need, you would accept the weight would go up.
I think if there was a proven need, yes,
Yeah,
but
okay.
I don't know why the lease hasn't been signed. That's
No.
between the scouts and the authority.
Yeah.
But there's no lack of intent on the authority's part to keep they're not being dispossessed of their current premises. You know, there's a discussion to be had. So but
No.
I don't know why it hasn't been signed. I
No,
can't comment on
although
that.
it's quite interesting, isn't it, that what Ms. Dring was saying rightly was that this is actually, although it's not included in the allocation in LPP2, the Scout site, it is right beside this allocation, which hasn't come forward as of yet. And what she said was that if there was a clause included to allow the council to move the Scouts, which is apparently what was being said, what the council wanted, it would allow potentially the council to expand the scope of any development of the Weyhill site because they'd have more land available. So that's a possibility that Ms. Dring was referring to, yes.
It is a possibility, but I
okay.
will go back to my point that the authority are engaging with
Yeah.
scouts. They're discussing that they wouldn't waste their time if there
No,
wasn't an intent to
but-
keep them in their current
no,
premises
but-
in
I mean, if-
preparing a lease.
But if it's right that there's going to be a potential to have a relocation clause in it, which is what seemed to be the position last time around, and I mean, you don't know where we are on that.
No.
Again, in terms of the security and future of the Scouts, on our site, freeholders, secure for all time. Even if they agreed a new lease with the council, at least potentially it could have a relocation clause in it and they might have to move again in a couple of years. Yeah?
If that was the
Yeah,
eventuality, and I'm
okay.
sure there are other premises around.
Yeah, well,
around the
You say there's other
local areas
premises,
that they could move into, or
Is-
share perhaps with another scout group.
But-
I don't know.
well, but not in Hazelmere, surely, because there's only one Hazelmere Scout group. So you could, if you want Hazelmere Scouts, they have to be in Hazelmere. But I mean, you haven't produced any evidence about there being other sites within
No.
Hazelmere that Scouts could go to. No, okay, good. Now, one other thing on things that have not changed, and then I think obviously it'll be lunchtime, we have a break. What I wanted to just understand is Mr. Collins' proof again, so his main proof. He has a table, 8.1.
Do you have a page reference?
Have you got that? So it's page 83.
Thank you.
Now, this is his critique of allocated sites in Hazelmere and Hindhead. And again, bit of a sense of deja vu because it was a very similar table 14, 15 months ago in Mr. Collins' evidence. But we are going to have to discuss later on the Royal School because you discussed that specifically, and it's one of the alternative sites, isn't it,
Yes.
that we need to discuss. And similarly, over the page DS8, the Old Grove, we'll need to discuss. But these are all allocations in the local plan, correct?
Correct.
And in terms of the position when we were at the last inquiry, none of them had planning permission, right? That was the position, correct?
Right.
At the
Yes.
last inquiry.
Yeah.
And at this inquiry, and we'll talk about this a little bit later on, but the only planning permission, as I understand it, that's been granted for any of these sites is on Old Grove, and that was for 18 dwellings, phase 1. Is that right?
Yes. Correct.
Thank you. Now, on all the other sites, I know we need to talk about Royal Junior School in particular, and I know we also must talk about Old Grove in particular. We may also have to pick up on a couple of other these, because I think a couple of others are also potentially in the alternative sites, aren't they, that you've referred to? Yes. But there's a commentary on delivery by Mr. Collins in the third column. You've not thus far, have you, other than I think in relation to the Royal Junior School and Old Grove, but correct me if I'm wrong, have you actually said that Mr. Collins has got anything wrong on his commentary on delivery on the other sites? Leave aside Royal Junior School and the Old Grove for now, because I need to come back to those. Has he got his commentary wrong on any of those, or have you not checked what the position is?
The position I set out is set out in my appendix 7 and
Okay.
in evidence in
Well,
chief as well.
All right, but let's just go through that, shall we? Because so DS01 Hazelmere Quay site, that's okay. So that's one of your alternatives, correct?
Yes, correct.
So we'll come to that later on. The next one, Central Hindhead London Road, is that one of your alternatives? Not sure. Don't think it is.
I don't think it is.
No.
No.
So you've not dealt with that one, have you then?
No.
No. Okay. The next one, Land at Andrews, Portsmouth Road, Hindhead. Don't think
No,
that's in. So again, you've not dealt with that one.
no.
No. DS04 Way Hill. Just checking. Is
No.
that's not in either, is it?
No, it's not.
No.
No.
Okay. Hazelmere Prep School.
No,
No. Okay. So again, you don't make any comment on that.
no.
Royal Junior School is in, so
Yes.
we'll come back to that. The Fairground, I think that is in, isn't it? That's your site 3 in the alternatives list, correct?
Yes, that's
So we'll
right.
come back to that one. Old Grove is, and we need to talk about that one.
Yes,
The National Trust Car Park, DS09. That's don't think it's in, is it?
don't. No,
No, I don't think that's in the
No.
alternative. So again, you've not made any comment on that.
no.
No. DS10 Hatherley Tower Road, Hindhead. I don't think you comment on that one, do you? Or the next one?
No, I don't think
No.
so.
Okay.
No.
Fine. So we'll talk about the ones that are in the alternatives list, but for those that are not, it's not part of your case to challenge, and you haven't challenged any of Mr. Collins' evidence about what the likely issues are with delivery, correct?
No.
No. Okay. Thank you. So that's probably a convenient moment.
Okay, sorry, just catching up on my note there. Yeah, okay, fine, thanks very much. Let's resume 2 o'clock, please.